guys, good morning. We're a little bit early, but that gives us a chance to make sure this works. They haven't started the stream yet on the trial. It starts in just a few minutes, so we'll see if we get some other viewers in here, and then once we do, we can go over what's going to happen today, what's been going on, and what could possibly occur. So let's switch over here. Kind of going right. So this is trial day 11, and this is the day when Darrell Brooks takes over his case. I believe the state will rest. I didn't catch if they actually rested at the end of the day yesterday or not, or whether they'll do it this morning. And I know that I did see that he told the judge, though, that he couldn't say how long his opening statement would be. He generally lies about everything, which may mean that he knows exactly how long it's going to be. Maybe he won't even do one, but I don't think he'll resist that. I think he will take this opportunity to speak directly to the jury when he gets it. So remember, an opening statement is supposed to be a forecast. The judge told him, look, this needs to be a roadmap of where you're going with your case, and that's a good way to describe it. It's not supposed to be an argument of how you got there. It's supposed to be a roadmap of where you're going. So he has allegedly, these other witnesses to call. He's already called one, so I think that would leave him with 11, although he wanted 13 for some reason. So this 11 witnesses that he's going to call, what will they do? What will they do for his case? What's his theory of the case? What are they going to show? This is when he should say that to the jury. Remember that he has kind of given contradictory cross-exams in terms of intent. In other words, was he not the guy there? They can't prove that. Was the vehicle out of control, even though maybe he was in it? It's hard to say exactly where he's going to go with what he's doing. What I'm going to do now is go ahead and get the other stream ready to rock. Should only take a second here. Okay, so let's just take it off for now since it's not doing anything yet, but it should only be a few more minutes. So if anybody's got any questions, good morning, then I'll try and answer it about what's going to happen and maybe some of the other cases that are going on, depending on how long they take to get going. So again, the theory is that he will start his case this morning, which he deferred his opening statement at the start of the trial. He can do it today. He indicated to the judge that he didn't know how long that would take. It's going to be interesting because I doubt he understands really the purpose of the opening statement, and I doubt he cares what the purpose is compared to whatever it is he wants to achieve. He's been trying to give many opening statements as it is to the jury when they come in and leave by arguing to the judge and trying to create the impression that there's something going on that is being hidden from the jury. Well, today, he doesn't have to do that on a bootstrap way of just catching their attention as they come in and out of the room. He will be able to speak to them directly and say what his case is going to be as he's going to call his witnesses. That's kind of what I'm mostly interested in this morning, is what's this nut going to say? So that's what we're going to find out, I think. It will be interesting because he shouldn't be making arguments in his opening statement. How much the prosecution will object to that, or the judge herself, if he starts to misstate the law or say wild things, is something we'll have to see. I'm sure they'd like to just get it over with, so they won't object probably as much as they would if an attorney were doing the things he's going to be doing, but there's only so much that they're going to want to let him get away with. So how's he representing himself? He's crazy, right? And I think it is reasonable to say that someone who murders people like he did and basically behaves the way he does is mentally unwell. And that is not the standard for whether you can be held responsible for your crimes or not, or else you'd have to let all the nuts go, like Jeffrey Dahmer or Ted Bundy, that sort of thing, because they're obviously crazy, right? So usually the legal definition of insanity is something much more limited, and that is you can't know that what you're doing is right or wrong. You don't have that concept in your mind because of your mental disease, or you couldn't control what your body was doing, or that sort of thing. You didn't know what was happening around you. So that would be tough for him, and I think essentially impossible, because he obviously did know what he was doing was wrong because he tried to evade the scene. That's evidence of that. If you didn't think you'd done something wrong, you wouldn't have left. If the vehicle were out of control, you could have stayed there. Now, he could argue, well, I didn't know that they wouldn't hold me responsible for it. Well, if that's your argument, that's further evidence you knew that what you were doing was wrong. So when you flee the scene like that, you're putting some evidence out there that I know I did something bad, and that goes a long way towards defeating an insanity defense. And then, of course, there's his interrogation with the police where he's trying to be wily, but he's very cognizant of what criminal charges can be, how to try to evade them, how to discuss it with the police. He was extremely lucid, said he wasn't under the influence of anything. So, an insanity defense for him for his primary charges, that wouldn't go anywhere. So how can he represent himself in court? Well, some cases get put off for incompetence to stand trial, that you can't help defend yourself. Like in the Lori Vallow case, I think they stopped that trial for now, saying that she may be incompetent or she is incompetent. So you may or may not be crazy at the time you committed the crime, but if at the time you're on trial, you're not competent to understand the proceedings, basically, to assist in your defense, then they shouldn't continue with the trial. So he was found competent, or at least that wasn't disputed in his case. There was no issue with his competency. And that goes a long way toward, if you want to defend yourself, establishing that you're allowed to do that because you do have that right. So once you're competent to stand trial, you only have the slight additional burden of convincing the judge that, look, I can navigate my way through this. I may not be good at it. I know I don't have the experience of the lawyers and things like that, but I know the language, I know the words, I know the risk that I'm putting myself in. I may be an idiot, but I have a right to do it. I have a right to be an idiot. And so it's not a much of an additional burden to be able to represent yourself as compared to just being found competent to stand trial. And he succeeded in that. I didn't really watch all of that, but once he succeeded in being able to defend himself, I thought, well, this is going to go off the chain, and started watching the case some. And it has, of course. He's picked up with his sovereign citizen nonsense. And I don't know why he fired his lawyers, except that his mother gave an interview and said he thought he would get the trial delayed. That's probably the main reason he did it. And maybe he wanted them to assert some of the sovereign nonsense and they wouldn't do it. I don't know. I mean, they know that's frivolous, and so they shouldn't be advancing those arguments, and that could be a source of conflict too. So it's not Burger King, and he doesn't get to have it his way. I did watch a little bit yesterday, retrograde on this, that the judge told him that if you fire your lawyers, they're gone. It's just you. So he wasn't ambushed in this. He demanded it as his right. So I don't feel sorry for him that he's not doing a great job. And honestly, despite the fact that he is kind of making a fool out of himself, there really isn't a defense here anyway. He's videoed doing the crime. He did it. I mean, that's it. This is the least mysterious crime that I think I've seen in a long time. He absolutely is guilty. I don't know necessarily why he did it, but he did it. So I think you don't often, especially when you're not in the courtroom, you don't know how the jury's going to be. Even when you're in the courtroom, you're kind of guessing. But yesterday, when they had the COVID query of the jurors, their voices were all strong, and they could have told the judge, hey, I have a concern about serving on the jury now that there's been this exposure. I'm really worried. I have this health condition, if they wanted to bail out. And when I listened to it, not a single juror took that out. They all said, no concerns, Your Honor. Male, female, every one of them answered, no, Your Honor, I'm fine. Very strong voices. If you're Brooks, it doesn't look good for you because they want to stay on this jury. They want to conclude this trial. They want to do their duty. And they sounded pretty solid to me. And given the mountain of evidence against this guy, I think they're going to do the obvious right thing and convict him. You never know, but I didn't hear anybody wavering yesterday. And if you were wavering and you didn't want the conflict of trying to deal with this, there was your chance to try and get an out from the judge, and it didn't happen. So we know yesterday the jurors went and saw the vehicle, and there was footage was put up of that later. Of course, the vehicle was basically destroyed on the front through a collision with innocent children and old women, men, just scores of people maimed and injured by this guy driving through there, purposefully accelerating his vehicle through a crowd of innocent people for whatever reason he wanted to do it. So let's see. I got some questions up here. He can work on his case at night. I understand he has access to various research tools, and they probably are very careful to make sure he's not too restricted from that as part of his ability to defend himself. Arrested development with serious anger issues. Yeah, I mean, why is he like he is? I don't know. But the stare down he had with the judge yesterday when he got really mad at her and said, "Are you asking me to do this or telling me?" And she avoided that conflict basically by saying, "I'm asking." And he said, "Well, good, because I do what I want to do. Don't nobody tell me what to do." He was furious. He stared at her after that until the jury came back in. And I tried to watch it completely last night with my eyes open because I never saw him blink when he was doing it. He was staring at the judge in complete fury, trying to intimidate her. If he could be violent in that moment, it appears to me that he certainly would be. It's just how this guy is. It's just how it is. I mean, obviously, the judge is the boss of the courtroom. The judge has a lot of legal authority. She can tell you what to do. And it's a bizarre situation where a guy in shackles, whose every movement is controlled by law enforcement, is telling the judge she doesn't tell him what to do. I mean, okay. Yeah, they do tell you what to do. So let's see. Somebody has got to pull out and do lunch break and come back later. I understand that. Seriously. Let's see. Was he under the influence of drink or drugs? Now, I think he did tell the police at one point in interrogation that he doesn't drink. He doesn't drink. And the guy said, "Well, I thought you had some beers." "Well, yeah, but I don't drink." Did he have any beer in him or not? I don't know. I don't know if they did a toxicology test on his blood or not, but he wasn't under any substantial influence of anything. He certainly wasn't drunk, and he declared he wasn't drunk. And he appeared very lucid in the interrogation. He definitely was trying to steer them away from what had happened and concocting a story on the fly of how he got into the city with a bunch of baloney. And kept asking him, "Well, what else am I in here for? What else are you looking for?" Which is not what you would say unless you'd done something else worse that you were worried that they were trying to find out about. So he's not as clever as he thinks he is. I guess this is possibly true, but I guess I was about the big money book deals. But I would say this, which is they seem to me uniformly yesterday to tell the judge, "No, I'm fine. I'm going to stay on this case." And yeah, this is a high profile case and anybody can do anything in it after that, I guess. But I would say my personal experience, generally speaking, with jurors is that they're people who try to take the job very seriously. They take the duty very seriously, especially when they see the judge does and the attorneys do, and they know the impact of this to their community. So I think they know they have to stand in the gap here. They have to do the civic duty. That's what I was hearing yesterday. And everybody gives lawyers a hard time, and that's fine, jurists too sometimes. But in this case, I think they're the kind of people I'm used to seeing on juries, which are just good people trying to do the right thing. Here comes the judge, and let's see if we can bring her into the game here and get this full screen. Or will my computer simply blow up, as it appears to have done. All right, let me try that again. If there is a way to mess this up, I'm pretty good at it. Could be their stream too, but okay, it wants to show me a commercial. Once that's over, I'll pop this baby back up there. Let's try it again. All right. If there's any sound imbalance, just let me know.
And then 1, 2, each. You give 1 to each party. Thank you.
We're going to find out what's going on. They usually do some preliminary matters before the jury is brought in.
Now you can.
So this could be crazy with the opening statement coming up.
You can. Sam, go ahead.
A lot of.
I was going to call the case. Okay. Do you need something to talk to him for a second? Yes. Go ahead. You can turn the audio off for a second.
So he's exercising his constitutional right to defend himself, and now he will have the chance soon, if the state has arrested or if they're about to arrest, to then address the jury in his opening statement, which he deferred from the beginning of the case until now. And I don't think he's going to waive it here. I think he's going to take this chance to talk to the
All
jury.
right, good morning, everyone. The court will call State of Wisconsin
says,
versus Darrell Brooks,
I
case
don't know if
number
he even
21
knows,
CF 1848.
we're all
May
about
have
to
the
know.
appearances, please.
Morning, Judge Schumacher, Leslie Basie, and Zach Witchow appearing for the state of Wisconsin.
Good morning, sir. Please state your name for the record.
Just 1 second.
Please state your name for the record. I don't know that he's done that.
They just coming late today.
He wants to avoid that.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and do not consent to being called that name for the record.
Okay, but what's your name? He won't say.
All right, thank you. That is noted. The record will also reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie and a mask as well.
Those, of course, are not his street clothes.
I
Church
understand,
clothes,
sir.
maybe.
All right, I do want to put on the record, I gave the parties this morning, it's an excerpt from a judicial bench book on opening statements. It's about a page and a half.
She wants to
I
make
thought it
sure
would
he
be
knows what the
helpful
rules are.
to provide
for
to
statements,
Mr.
not
Brooks as
arguments.
he puts together his opening statement. It has reference to some Supreme Court rules, SCR, some case law, talks about the manner and purpose, scope, and other things. And
She is
as I indicated
earning her
yesterday,
salary
sir,
in this case, doing the best she can
the-
for both
I
sides.
like to call it the roadmap. It's referred to here as a framework.
Particularly
so
when
that the jury can
he's not
better
trying to get
understand
himself
and
off
evaluate
by being innocent
evidence.
for
It must
actually
also
flaws in the
be,
state's case. He's just trying to
based
game the
on
system in a ham-handed
the
way.
law
And
and
she's
the
got to be
evidence
careful that he doesn't
believe is
succeed in
properly
that.
admissible. I'm going to further advise you at the time when you do make your opening statement that it not reference subject matter jurisdiction. That
Nice.
is, despite what I know you believe to be to the contrary, it is not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments. With that, I
For the
believe there's,
record, is this the, which you're referring to, this?
Got a question about the bingo card, and
page
can
and
it
a
be
half is
played
from
for
my
defense
judicial
side?
bench
I think
book.
it still
thought
can
would
be. I think
helpful
his
to you is so
bag
that
of tricks
you
is kind of
have a
limited.
better
It's a
awareness
magic 8
and
ball of idiocy.
understanding of
He
the
only knows
manner
a certain
and
number of
purpose an
things to do other than
opening
get
statement.
mad and
This is
threaten
what
people.
guides me as I preside over cases.
Okay, I accept for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that that wouldn't be part of an opening.
Experienced trial attorney
statement.
Darrell Brooks has letting the judge know that he doesn't
Okay,
need
great.
these
I don't
basic
get why
instructions.
that-
I wanted
on.
to make the record clear.
He's never
So I
claimed that
appreciate
in
you
an opening
indicating to me
statement.
that you're aware of that.
Even though subject matter jurisdiction has not been proven on the record
Oh, yes.
and should
Sir,
be
it does
addressed.
not need to be proven on the
It-
record. It's
it-
established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
Constitutional
it-
scholar
who
Darrell
was the
Brooks and
complaint
sovereign
filed
idiot
by?
Darrell Brooks.
Because subject matter
Sir,
jurisdiction
disputing the
has
I'm
been
not
judge's
going to go
proven
down
on the
this
record.
path today. I'm just advising you, you cannot reference that in your
I
opening
mean-
statement.
That was something I've already had the common sense to know, but
Oh,
also
okay, right.
subject matter
You don't have the
jurisdiction
common
has
sense
not
to
been
know
proven for
that the
record.
rest of what you're saying is stupid.
All right, next
just likes to
topic.
argue.
Then, I believe the state has
Should be
filed a
proven for the record.
motion.
I mean, if you
By
can't
the
beat
prosecution.
women because you're shackled, you can at least
Objection is
argue with
noted.
them, right?
It is not legally sound.
That's what
It's
he's trying to do
overruled.
here.
It's definitely legally sound.
All right,
Has yet to be
Attorney,
proven.
I'm going to turn to Attorney Opper. I believe they filed a motion this morning. Has it been pulled through? I probably just need to refresh, but Madam Clerk.
This is going to be
Served on
bananas.
Mr. Brooks last night in the jail, Your Honor.
She has a migraine. or should have one. Wonder what she's
All
got in
right,
that
go
cup.
ahead, you can make,
It'd be excusable, whatever it may be.
I didn't look at the document.
Of course not.
I accept accept for value, return for value the document. I didn't look at it.
Okay. It's your choice. Okay.
So I don't know what I'm supposed to say to that.
all right, well, Attorney Opper, it's your motion, I'll hear from you.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads, as it reads right now, it reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more
Yeah,
consistent
that's a fact.
statement that aligns with the testimony of victim P.
The odds of
Eric
objection
Patterson
from
as she
Brooks,
testified in this
100%.
trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts.
Criminal procedure
of this
expert Darrell
transaction.
Brooks will object to this as a material
Reflected
change
in
despite
a
the
number of
prosecution
police reports
statement.
And Ms. Patterson's recorded statement, which the defendant has copies of. And so.
Middle DA blowing her nose in court.
Grounds for
Only a few months
claim of
ago, that would have
prejudice
scattered
by
the
this
room.
change, and we're asking to move forward with that amendment to the information.
All right, thank you. Any position on that, sir?
Yes.
Yes, objection, Your Honor.
First of all, for the record,
For the record.
there were originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been.
That's a great
that
point. If you have
topic
one
could have been visited at that
non-material
time
word
for
that
it to
didn't get
change.
changed, you shouldn't go to jail for murdering 6 people and maiming others.
Really has any.
That's a great point.
bearing on
Like this
the
is a traffic
testimony
ticket.
or the actual charge. I don't understand why
Not sympathetic to this guy.
a motion needs to be heard about one word. Is think kind of.
If you can get your eyebrows higher, she may agree with you. A little higher.
Charged like this for a year, basically. The language hasn't ever been referenced to being changed before yesterday.
And now repeat it
What
again.
is the significance of this now at this point?
Okay. Thank you.
Thank you, sir. Court is guided by Section 971.29 sub 2 of the Wisconsin statutes, which provides at the trial, the court may allow amendment of the complaint.
She's never
indictment,
needed
or
3 monitors
information
at her desk,
to conform
more
to the
than she
proof
has in
where
this
such
case.
amendment is not prejudicial to the defendant. Case law states that when an amendment to the charging document does not change the crime charged, and when the alleged offense is the same and the results from the same transaction, there is no prejudice to the defendant. State versus Wickstrom, 118 Wisconsin 2nd,
Nice.
339, found at page 348. It's a
Let's
Court
see
of
if he
Appeals
accepts
case
this
from
or goes bananas.
1984. And also, I point the parties to State versus Durango, 229 Wisconsin 2nd, 1.
So when they both finish the
State
case, in
versus
theory,
Gerard,
the prosecution will give a
189
closing
Wisconsin 2nd,
argument.
505.
Brooks will give a closing
First of those
nonsense,
two cases
and then the
is
prosecution
Court of
would
Appeals
have a
case
final
from
statement on it because they have
1999.
burden of proof.
And then the second of that.
So they're
of those
usually allowed
references
to,
from the Supreme
to
Court
go
from
last.
1995. I'd also point the parties to State versus Frey, 178 Wisconsin 2nd, 729, a Court of Appeals case from 1993. As far as whether this is a moot issue or not, I'll find that it is ripe for determination by this court to
Notice she said
hear this
moot.
motion, and that is
Often confused with
because
mute.
the jury ultimately will be instructed similarly to what the jurors were instructed at the beginning of the case. The charges are read, those are based off of the information, and this proposed amendment does conform to the proof. There is no prejudice to Mr. Brooks. It does not change.
He disagrees, I
The
suspect.
charge in any way. It is still the same offense. It's still from the same general
I still want a
information
third party
that
intervene over the
was
removal of the word phrase
indicated
Sally
in the
port
criminal
yesterday.
complaint. So for all of those reasons, I will grant the state's request to
The judge was on
amend
target with that.
the information, and the state may file that document as soon as possible.
I have a question about that.
Okay.
So, this same person is scheduled to testify again. What if something changes in the testimony?
Then we just throw the
I'm not gonna
charges out
answer
and
that,
give
sir.
you
It would
a new truck to
require me
run over more
speculate
people.
on what that
Yeah.
situation might be and to give an advisory opinion, which I will not do.
She's not your lawyer.
What happens if that happens?
I'm not going to answer that, sir. I
What
can't-
happens
you're
if
asking me
fools
to
fall
give
in
an
love?
Advisory decision. I'm not going to do that. I'm not allowed to do that, actually. Okay, so we dealt with that.
Second reference to the judge is the saint.
The
I
state
can't
has
argue.
not rested yet.
Now, they have not rested
Will the
yet.
state
I didn't catch the
anticipate
very end of
calling
it
any other
yesterday.
witnesses?
Yes, Your Honor, as indicated yesterday, we do intend to recall Detective Casey.
She's
to the
using
stand,
maximum
and I'd
Wisconsin
like to, make a
accent.
record in that regard, please.
Go ahead.
So
Your
a
Honor,
recall, this will probably be pretty
Detective
short.
Casey did testify once for the state early in the presentation of the matter. His focus at that point was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury, the different parade units that were impacted, what they looked like. We showed several videos with Detective Casey just for background and context purposes. He then went on to describe his personal interaction with the SUV.
Interesting
as
to
it
see
came
what
through
they
the
think they
intersection of
missed.
White Rock and Maine.
That they need to call him back
And
for.
essentially, that was the bulk of his testimony during his first testimony. We're seeking to recall him now. This is not unusual. It is
Her
commonly
expression
done.
represents
in
what she knows is
cases.
gonna
We never
happen when
excuse
she
him from
finishes
his
and she has to
subpoena.
listen to
We
Brooke's
never asked for him
reply.
to be excused from his subpoena. We always intended to recall him.
Oh, that's interesting.
We did this
Okay.
so that we can efficiently present the information to the jury. The types of questions we have for him now go more to the investigation itself and his role as the lead detective in this case. There will not be duplication or repetitive questions. I'm not going back to the corner of White Rock and Maine with Detective Casey during this round of testimony. We want to ask him essentially about how some of the victims along the parade route were identified.
So I suppose this will be
We want
their
to ask
last
him
witness.
about
Then they'll stop,
some of
and
the
then it'll be
topics that have
opening
been
statement time for
addressed
Brooks.
throughout the course of the state's case as far as identification of the vehicle and identification of the driver. And we need to still introduce the certified bail forms from Milwaukee County for the 2 bail jumping counts. So he will be asked about that. I estimate my direct examination of Detective Casey would be about 20 minutes. So
Okay.
this is not going to be repetitive. It's information, again, that he has as the lead detective in the case to assist the jury in understanding some of the things on the back end that he was involved in, not his role at the parade. So we are, we have been very efficient in our presentation.
That's true.
I believe Your Honor would
I think of
agree
the
with that.
magnitude of this crime, this
We're
case
not
has gone
wasting
pretty
time here,
rapidly.
but we
I mean, sorry,
just
this
have
trial has gone
a
pretty
few more
rapidly.
questions to wrap this up.
All right. Any position from you, sir?
I
Yes,
think he's
do.
against it.
And I'm gonna start with what was just said, that the prosecution feels that they've been efficient in their presentation. So it seems like to me, an attempt to get more questions in that could have been asked in the first place. That if Your Honor recalls, Detective Casey was testifying for quite some time, to the point that we actually had to have a break before I can cross-examine Detective Casey. If you
He's
recall.
actually thought this
He
through.
was up there quite some time. That was more than enough time for any other foundations to be laid, any questions to be asked at that time. And also, from my recollection, he was asked to be excused. So essentially having him start off and then end it, I feel like it's an attempt to get questions that was maybe forgotten to be asked, answered. And essentially what more could be gained by a second testimony from Detective Casey?
Well, I would have left
What more could be
that
gained
part out. They just told you what they
hasn't already
wanted to gain
learned
from it.
about vehicles and identification by numerous witnesses. We've been through the
Well, I agree with him. There's a mountain of evidence
inspection
against
of the
him.
vehicle. We've been through DNA analysis of the vehicle.
He said yesterday that he wasn't going to say yet whether he was going to
Numerous
testify
things in
himself or
regards to the
not.
vehicle. Even
It seems to me that it would be hard for him to resist that.
Even the
But I think you got two things there. One is,
testimony.
does he really believe the
If you want
sovereign
that,
nonsense? And in that case, he doesn't need to tell a stupid
seems like
story to
nothing
try and
more than
defend
get
himself.
extra
Or does he want to
questions
try and
answered that
spin to
could've
the
been
jury
asked from the get-go.
the ridiculous story that he was trying to tell the
Seeing as how
detectives
he was
that
up
he
there
was
for quite some
only in
time,
town to watch a
and
football
none of those
game and
issues
collect
were
some
raised
money
at
and
that time.
had nothing to do with this vehicle, et cetera.
would
Given
be the
the evidence they brought out, like what
significance
new
at this
story could he come up with? If he does testify, they will be allowed to cross-examine
Essentially,
him,
I should
including
be
using this
already
prior interrogation and things like
presenting,
that. So
my defense at
they
this
can't ask
point
him
to
questions
trial.
at this point, but they could if
see the
he
relevancy of it,
testifies.
and
I think
to
it's
my
hard for him to
knowledge,
resist, but I can't say. Maybe we'll get a clue when he gives this opening statement.
Thank you,
What's the
sir.
relevancy?
Thank you, sir. The court has discretion under 90611.
90611.
It's a statute I've quoted with frequency during the course of these proceedings. I've listened to the state's offer of proof. I've listened to the objections made by the defendant. In my discretion, I am going to allow Detective Casey to be
here we go.
recalled for the reasons laid out by the state. As I understand his proposed testimony today, it is not to rehash topics that he was questioned about initially. This has to do with his investigation and role subsequent to the initial contact with Mr. Brooks at the beginning of the parade route. And as the state indicated, we'll address certain things, including identification related to the vehicle, of the driver throughout the investigation, identification of certain victims. In addition, there are 2 additional charges for which the state has not yet presented testimony, so it's proper for those as well. It's relevant, and I will allow it for those reasons. So the state will be able to recall Detective Casey, and we'll have that done, obviously, when the jury is brought out. Any other preliminary issues then from the state?
Think he's going to let that one go?
Your Honor, just, I am
Looks like
working
it.
on going through our list of exhibits, and I will work with your clerk to make sure that everything that I'm showing was admitted and accepted by the court is what she has, so that we can clear that up before we actually rest.
All right, thank you.
All right.
Anything preliminary from you, sir?
Yeah, just a quick question about that last thing again.
You didn't let it go.
I will be able to re-cross-examine,
Oh, yes, you will.
and
You can re-cross-examine.
is essentially anything left off limits to my cross, or what?
I may limit, depending on where we go, if the questions deal with what he testified to previously. It's primarily to cross-examine based on the new testimony. However, 90611 also says this: witness may be cross-examined on any matter relevant to any issue in the case, including credibility. It does say in the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct. So I'll give you some leeway, and I'll trust the state will make appropriate objections, and I'll rule on them if and when they're made.
Because I'm not intending to go too much back into the previous testimony, but I think it may.
I think it's
few
critical
points
that
from
we know
earlier
whether he
testimony
knows the
come into
plaintiff
play, and I
in this
just wanted to
matter
make
and whether
sure
he's filed a claim.
think that's fair.
That hasn't
that
come
wouldn't
up
be a problem.
yet.
I think that's fair, sir.
Also, really quick, I did look over some information provided by the prosecution as far as the pretrial offer that I did not have knowledge of until, I don't know if that was today, Thursday, I don't know if that was Monday or Friday or Monday, one of those days. I've put together, started to, I won't say it's completed, that wouldn't be fair to say. I've
And we
put
know he wants to be
together,
fair.
Or started to put together a counter offer, so I just wanted
A counter offer.
to advise the court that I was putting that together.
Okay. Cool
All right,
story.
Thank you, sir.
Cool story.
And if and when you do provide that to the state, please let me know so we can make a record of that. All right, anything else? If not, then
Go time.
the jury brought out.
We do have one last large map here, Your Honor, I'm going to ask to put up and face backwards like we did the other day.
All right, go ahead since the jury's not here.
So remember, one reason they're doing the stuff with the exhibits is the judge doesn't want the parties walking up to the witnesses to give them things because she's not going to let Brooks do it because he's in confinement. He's actually shackled right now. They have the little curtain in front of the attorney's tables, and that's so the jury doesn't see that's the case with him, and they have it in front of the DA's table too, so the tables look the same. So she's tried to make arrangements where the parties would not need to approach the witnesses on either side, so there wouldn't be the appearance that one side could do it and not the other. So they try and put these things up there ahead of time, or they have the witness carry them up there with them when they go up to the stand, or bailiff, I guess, take it or something like that.
Thank you.
So the jury comes in, this guy gets examined again, and then whatever time it takes, and maybe they'll have this happen during the examination, the exhibits are tracked between the clerk and the DA to make sure they're not missing anything. Everything's admitted they wanted admitted. Then they're going to arrest.
All rise.
It'll be the defense turn, and he'll make an opening statement, it appears, and we'll see what this guy has got in his mind other than air. Clearly, if they hadn't had all the outbursts yesterday, they would have gotten this guy out there and finished
Thank you, everyone.
yesterday.
Please be seated, and good morning,
Prevented
ladies and
that from
gentlemen of the
happening.
jury. I know it's a little chilly in here. I'm not sure if that will change now that we're all in here. If at any time that temperature is too cold for you, let me know, and we can have that adjusted. All right, Attorney
It's not a
Alper, you may
complaining
call
kind of
your next
jury.
witness.
Thank you, Your Honor. The state would recall Detective Tom Casey.
Good morning, Detective Casey. Please make your way to the witness stand. When you get there, please remain standing, raise your right hand, and Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so
You
help
know
you
it.
God?
Yes.
Thank you, sir. Please have a seat.
Casey at
Please
bat.
state your first and last names for the record.
Thomas Casey.
Thank you. Go ahead, Attorney Alper.
Thank you. Detective Casey, I'd like to begin by asking you to refer to the item behind you. There's a large poster board there. If you could please place that on the easel and identify the exhibit number for the court.
So different court reporter today. See that?
It's exhibit number 15.
Thank you.
I think we've seen, yes,
And
we've seen this
had
before.
testimony about this exhibit throughout the trial, is that right,
Yeah,
sir?
I've seen it more than once.
Your role in this case was what, sir?
Objection leading.
Overruled.
Initially, I was on traffic control for the parade. Shortly after the incident happened, I was assigned as lead detective for the case.
So remember, this guy has
Were you the,
testified
individual who
before.
created this map,
So
State's
this
Exhibit
shouldn't
number
be too
15?
much.
Yes, I did.
Okay. And I would like you to talk a little bit about how victims were identified in this case.
Objection leading.
Overruled, foundational, the witness may answer.
So at least initially, can you tell us, like, in the day or two after the parade, what happened?
Objection leading.
Overruled, you may answer.
So initially, that night, we knew that the victims were taken to different hospitals around the area, generally 5 different hospitals. So at the beginning, we began by having detectives assigned to each hospital.
This is a new person at the front of the screen, maybe from Guinness Book of World
They
Records,
also had a lieutenant that
tracking
was assigned there
a
as
record
team
number of
leader.
objections.
As the patients came in, they were identified by detectives. The hospitals also provided us with lists of patients that they had, and we went through those lists and tried to identify people that came in and were being treated.
Awful.
And then eventually, were there follow-up interviews conducted with these individuals?
Yes, there were.
What if the individual was a person under the age of 18?
Objection leading.
Overruled, you may answer.
If the person was a minor under 18, then we would reach out to their parents, talk to the parents. Some of the kids weren't able to talk to us, but we got the majority of their statement from their parents.
Okay. And do you believe that the names on Exhibit 15 truly reflect all the injured victims that you were able to identify in the course of this investigation, sir?
Objection statement.
No, I do not.
Hold on, there's been an objection, it's overruled, and the witness will repeat his answer.
No, I do not.
Can you explain that?
Objection leading.
Overruled.
Just because of the scope of the investigation, we had so many people that were hurt, we had to come up with some kind of parameters to limit the people that we would call victims. One of those parameters is that they had to receive treatment at a hospital. Another one is that they had to be in the street when their injuries occurred. So there are some people that were injured, maybe on the sidewalk, trampled by the crowd, or received injuries that they didn't get hospital care from. You know, and unfortunately, I learned later on there was even a person that was in the band that somehow we missed her being reported that she received a broken leg. So there are some that are not on the map, but all the people that have been charged
This judge has
are on the map.
done this about
So you mentioned people on the sidewalk. We did have some
as
spectators.
patiently as
testify
I
at the
think a
trial,
human
correct?
could possibly do.
Objection leading.
Overruled, foundational.
Correct, but they were more in the roadway or on the curb, not on the sidewalk, or not running away from the incident when it happened.
I see.
He just objects
So-
all the time. All the time. A magic
Was, in your
8-ball
mind,
objection
when you were,
machine.
Leading this investigation, trying to identify victims, what was the importance of the SUV in the injuries that were caused?
Objection leading.
Sustained as to the form of the question, please rephrase.
Got one.
Why were the spectators that are on this map included?
Because they were directly contacted by the SUV that came down the street.
Wow. Good
If a person
rephrasing.
were injured because they were trampled by the crowd, are they on this map?
We
Objection
exclude those,
speculative.
Overruled, the detective may answer.
those people were excluded from the map.
There were some people like that, right?
Yes, they
Objection
were.
leading.
Okay.
Please make
Sorry.
sure.
I
Thank
know.
you. I'll allow his answer to stand. Next question.
All right. I'd like to put up for you exhibit number 32, which has been previously identified. I'm sorry, admitted.
I'm sorry, you said 32?
Yeah.
You said 32? Okay, thank you.
He's
Sorry, I
just trying to
missed it.
slow things down for the most part and be disruptive.
Just to the witness or published, because it's been received.
Yes, we are going to publish this, Your Honor.
Go ahead.
But I-
Permission granted.
Okay, thank you. And while we're waiting for it to come up in the jury box,
I don't have it on my screen.
It may take a second. Hold on. If it's not, let's check the cables.
We don't have it
Yeah.
either.
In
see
Wisconsin,
it.
it's
The
illegal to
witness
have
can
a
see it.
coffee mug that does not have a logo on it.
Go out it.
I have a check that.
Thank you for
Seems
letting
to
us
be
know,
true
sir. and
Just the
we'll-
front
Based on
tables, back tables.
what I
on
see in the
there.
courtroom.
Hold on. Stop source for a second.
They had that mafia IT director on yesterday. He could have fixed this ASAP. Maybe I should recall him.
I know. It's,
Exactly. And repeat again that
You can see it
we
on the
watched
screen,
yesterday
though,
his
right,
stare
sir?
down when he yelled at the judge, how he stared at her with
There's
violence in his eyes
screen, obviously,
without
far
blinking
side of the courtroom, and
until
then
the jury was
here.
in the room.
Right.
It's always better on here because
I understand. We'll get our tech guy over here to look at it, but it's
just look
previously
at it.
been received and we can see it on
Yeah,
the
get
two
over it, bro.
other monitors. So for now, we're gonna continue. If there's anything
Objection.
new, I'll make sure to pause.
Objection,
Go
my
ahead.
monitor's not 4K.
Detective Casey, I want to focus your attention specifically as to the extreme dance team.
Okay?
We heard testimony about several of the girls on the team being struck and injured. Do you remember that testimony, sir?
Yes, I do.
Overruled, it's foundational. The answer may stand.
Do you know if there were other people associated with the extreme dance team that were injured?
objection speculative.
Overruled, he may answer.
Yes, I do.
And do you know the names of these people?
Objection, hearsay.
Overruled, he may answer.
Yes, I do.
What were their names, please?
Kathleen Pellmeyer,
Speculation.
Overruled.
Look at that detective is
answer.
everybody right now.
Go ahead, sir.
Kathleen Pellmeyer, Jennifer Stover, and Mitchell Lampine.
What was their role with the dance team?
Nice.
Go ahead.
Jennifer and Kathleen were support people. Jennifer's daughter was marching the parade.
Detective
and
is
then
awesome.
Mitchell was there to hand out candy with his stepmom.
Okay. I'm gonna now play, it's still not being displayed on our tables, Your Honor, but it is displayed on the two large monitors in the courtroom.
Gonna stop calling him a magic 8-ball because it's
So,
gonna make
do I have
me
permission
hate
to
my own
proceed?
magic 8-ball.
Which exhibit?
Take it to the
This is
range
32.
and destroy it.
Oh, yes. If we get to a new one that hasn't previously been received, then I
Yes,
will
okay.
pause to get
Alright.
the tech people in.
All right. and
Go ahead.
the
Objection
bailiff-
as to relevancy.
Overruled.
The bailiff confirmed it's on in the jury box, Your Honor.
Thank you.
All right, please play. From the 32-second mark, I'm sorry, 35-second mark to 47
That guy
seconds.
does not care at all that he killed and injured these people. Look at him. He doesn't care.
Looks like it's a minute 23 according to what I can see on my monitor.
Definitely.
It is 123 total. We're only playing this 12-second clip from 35 to 47.
Thank you.
Objection. Clip's over 10 seconds.
And please pause. Do you see any of the individuals you were just testifying about enter the screen, sir?
Objection speculative.
Overruled, he may answer.
Yes, I do.
Could you identify them by using the touch screen?
Objection leading.
Overruled, he may answer.
I'm gonna draw one big circle.
Okay?
You know, why did he do
It has
this?
two individuals.
Why
It has
would he do
Jennifer and Kathleen.
Look
Kathleen
at
has
the
red
little kids
jacket
on the sidewalk.
And directly to her left would be Jennifer in a black jacket.
Okay. A little hard to see
Awful.
right now, but as
Yeah,
they,
very hard to see.
Thanks for the commentary, murderer.
as they
Keep
walk,
going.
could you see two people walking there, sir?
Yes, ma'am.
Okay. Please clear the screen and continue playing. And pause. And I'm sorry, because I can't see the counter, Your Honor.
It is at 44 seconds.
44 seconds, thank you. Paused at 44. Do you see anybody else that you just testified to in the video at this point, sir?
Objection speculation.
Overruled,
Stupid.
he may answer.
Yes, I do.
And who is that?
Leading.
Mitchell,
Objection.
Who is it is leading?
Overruled.
God.
Mitchell Lampine.
Please circle Mitchell.
Hmm.
Did you know Mitchell's approximate age?
Objection speculative.
Overruled.
I believe he's about 10.
Okay.
He doesn't care that he killed these people.
All
He
right,
just
we
doesn't.
can, take down 32. Did, this video goes on to show the red SUV drive through the extreme dance team, correct?
Objection leading.
It's foundational. Your Honor.
Overruled, it's foundational, it's previously been received. Go ahead.
The DA has had enough of
Yes,
this
it
crap.
does.
To your knowledge of this video, sir, did those individuals, Mitchell and Ms. Stover and Ms. Pellmeyer, remain along the left side of the road there as the SUV
Objection.
went
I don't
through?
care about people that got killed and hit by me.
Overruled, the witness may answer.
They were hit by the vehicle and then moved to the left.
Let's take a pause for a second. We
Yes.
are IT experts. Hopefully I can get this figured out.
It's a lot of pressure.
Go ahead.
You're going to need to unplug it and plug it back in.
Next one will be 132 if you want to. Oh, I'm sorry, 55.
It's on our screen.
It's on now.
Hold on, let's make sure. Do you have it now, sir? Yes?
Yes.
Oh, good, great. It's on mine, it's on the witness.
Nice.
All right.
Just
Thank
like
you.
real life. You call the help desk and they show up and oh, now it works, yeah.
Jury monitors were working. It's not, hold on, let's make sure. It was just working. There's a delay.
He doesn't really need to see it since he's the one who did it. He just likes to cause trouble.
It can take 30 seconds.
Remember that one time where he pretended like he was a little bit upset that he killed somebody? Then he didn't bother to do that anymore.
What exhibit is this one?
This is 55.
All right, it's on. Very good. We're up and working. And 55's previously been received, so go ahead.
All right.
Objection to the relevancy of 55.
Yeah, all right. What is a
No,
video
no,
with the actual
overruled.
murder? How
Go
can that
ahead.
be relevant?
Detective Casey, exhibit 55, can you see at the end of the road there, or the top of the screen, what unit is involved in exhibit
Yeah, we watched
55,
his
please?
interrogation yesterday and how he just told a stream of lies to the
Yes.
police, just completely made up
Tell us.
things.
Objection leading.
Overruled.
Lying is what he does, and
It
playing
is the
games is what he
dancing grannies
does.
that are approaching from the right.
Okay. And one of the dancers, we have her testimony that was involved with the grannies was a woman by the name of Lola Hospital. Is that
Objection.
correct?
Objection leading.
Overruled. It's foundational. The witness may answer.
Yes, she was.
Is there video showing Miss Hospital being struck by the SUV?
Objection leading.
Sustained is to the form of the
Oh,
question.
God, Judge.
Please rephrase.
Sure. Is the exhibit, you've seen exhibit 55 before?
He's staring at him to see if
Yes,
he
I have.
says a stupid objection.
Are
I
you
like
able
this
to
guy.
identify Miss Hospital, I'm sorry, yes, Lola Hospital in exhibit 55?
Objection leading.
Objection leading.
Overruled.
Yes, I am.
All right. We're going to play the clip, Your Honor,
Hmm.
from from 4 seconds to 8 seconds at 50%.
So you don't have to
speed,
object to everything,
and
even if you're going to
zoomed
win
in,
it. And typically you
middle of the
don't,
road
because if you're
where
just
the
being disruptive, or if it can
dancing
come in
grannies
two
are.
questions instead of one, why would you
All right, go
bother
ahead.
to
Thank
do
you.
it? It's just his game. But a video of someone being hit by the SUV and it plowing through the parade route, he objects on the grounds of relevancy like he did the SUV
Overruled.
itself. So that's,
I saw the
even
red
he's not that
SUV
dumb. He's just being disruptive.
driving westbound on Main Street, approaching the Dancing Grannies, and hitting Lola Hospital and then striking two other Dancing Grannies.
When you say hitting Lola Hospital, what did you see?
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Miss
I
Hospital
think
report any
cross-examine
injuries
this
to the
guy by
Waukesha
Brooks
Police
will
Department?
not go well for Brooks.
Objection leading.
Overruled. The witness may answer.
Yes, she did.
All right, sir. I'd like to now ask that Exhibit 118 be published for the jury. This has previously been admitted.
Permission granted.
This DA was out of sorts before the witness came on, maybe because she had to prepare for this exam.
Received.
She deals with videos
Go
of people
ahead.
being killed by this guy. That would
Sir, do you
do it for anybody, I
recognize
think.
the item
Yeah, look at that.
shown in Exhibit 118?
Yes, I do.
And in addition to the photograph, have you had an opportunity to examine that item or items
Objection, leading.
personally?
Overruled, the witness may answer.
Yes, I have.
And Mr. Johnson from the crime lab testified about these items yesterday, but I'd like you to tell the jury what you remember of these items, please.
Objection, leading. Affirmative. The first part of the question.
Overruled, the witness may answer.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket.
Awful.
And a hat, a black hat with snowflakes on it, being
Wow.
pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a
God.
disparaging remark for the record.
Yeah, we shouldn't disparage this.
Your objection is noted, and the answer will stand.
There was also a blinking
I will
headband on
instruct
the
the
side mirror.
witness to simply
Awful.
describe what he is
Look at
seeing
this poor detective.
without further characterizing it, as it will be up to the jury to determine the facts in this case. Go ahead.
Thank you. When you saw these items on the hood of the red SUV, did you later come to recognize where they may have come from?
Objection, leading.
Overruled, the witness may answer.
Yes, I did.
What did you determine?
I determined that they were the jacket, hood, and hat that Virginia Sorensen was wearing while she was walking in the parade.
How terrible is that?
Like to display to the witness only, please, Exhibit 177. This has not yet been received, Your Honor.
All right, go ahead, please.
Is 177 on your screen, sir?
Yes, it is.
So again, she was kind of out of sorts this morning, and
What do
this
you
has to
see
be
in
why.
Exhibit 177?
Objection, leading.
Overruled.
I see two dancing grannies carrying a Milwaukee Dancing Granny sign, and the woman on the left is Virginia Sorensen, and she's wearing a black hat with snowflakes, wearing a white jacket with a hood on it.
Move to admit
Absolutely
177 and
terrible.
permission to publish, Your Honor.
Objection to the relevancy.
Yeah, how's
The
that
objection
relevant?
is overruled. Exhibit 177 is received. Permission to publish is granted.
Picture of this woman in her last moments trying to bring joy to people
177,
before you
yes.
murdered her. That's irrelevant to you. We know that. We know that's not relevant to you. Only you're relevant to you.
Go ahead.
That's why you need to go away.
And if the jurors would let me know when
Thanks
it's in
for
the jury
this.
box as well, please.
And I
All right, thank you. It's there.
overrule should get a big
Again,
workout in
just
this
so we're
case.
clear on the record, please
Absolutely.
circle Virginia Sorensen in the hat in this picture.
Objection, leading.
Overruled.
That is Virginia, and then this would be the hat and hood that I believe was found on the SUV.
Detective Casey, there were many videos that have been shown to this jury, correct?
Objection, leading.
It's foundational, Your Honor.
Overruled. The witness may answer.
Yes, there has been.
To your knowledge, are there any videos
She said
that display
this
the
guy would be on
license
about
plate of
20
the red
minutes,
SUV
so
as
she's
it
probably
goes
close
along
to the
parade
end.
route?
Objection, leading.
Overruled.
Yes, there are.
Is it possible to capture a screenshot from those videos to see the license plate of the red SUV along the parade route?
Objection. Hurts my case.
Yes, there are.
I'd like to display for the witness only, Exhibit 150.
Go ahead.
Is 150 on your screen, Detective?
Not yet.
Okay,
It is now.
all right. Do you see
One
Exhibit
thing about
150?
having defense counsel there, which he
Yes, I
doesn't
do.
now, is they
Please,
can mask
describe what you see
what an
in Exhibit
inhuman
150.
monster
Objection, lead.
is sitting there
Overruled.
in a murder case like this. It's
I
a lot easier to see
the red
here.
SUV that was driven through the parade route, and it's at the time when it was contacting the Waukesha South band members. In that photo, you can read the license plate number.
Do you believe this photo is a true and accurate representation of the events of the day?
Yes, I do.
Move to admit 150 and permission to publish.
Objection. How does this go to
The judge needs to get her own laminated overruled sign
Overruled.
investigation?
to go with back to the objection.
Exhibit 150 is received.
Laminated
Permission to publish is
sign.
granted.
Let's see that license plate.
The image is a little blurry, correct?
Objection.
A tad.
You know, he was staring at the guy
Can
waiting
you
to see if he'd
please,
object.
point out
Awful.
the license plates in the photo and read it for the jury?
Is it okay if I circle it?
Yes.
Overruled. You may do so.
Visual acuity expert
That is
Darrell
license
Brooks
plate
will
number,
object.
and I read ADP 9256.
All right. Now I'd like to show to the witness only, number 151, please.
Go ahead.
Please describe 151. Oh, please clear the screen, Madam Clerk.
This photo is of the red SUV on the parade route. It's just photo taken just prior to the Barris Logistics float, and the band director is in the lower left-hand side of the video. It shows the red SUV with the license plate number displayed.
Do you believe this photo represents a true and accurate depiction of the events of the day?
Yes, I do.
Move to admit 151 and permission to publish, Your Honor.
Objection to relevancy.
Yeah, how's
Exhibit
that relevant?
151 is received. Permission to publish granted. The objections noted and overruled.
Again, murder weapons are rarely relevant in a murder case.
40 exhibits. How do we get this many?
Keep going, Attorney Upper.
Detective, please describe what you see in 151. I think you did describe it. Strike that. Please circle the license plate and read it for the jury.
Objection, lead.
Overruled.
ADP 9256.
Thank you. It's still not up. Okay, I'm sorry. Gotta wait for the jury.
So again, this should be the last witness. Then the state will rest, and then Brooks will have his chance to make an opening statement.
Detective Casey,
That's what this
during
stream is
your
for today.
investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with this same license?
Objection.
Objection.
It's bad for my case.
Their name misleading the witness.
Overruled as to both counts. You may answer.
Yes, we have.
Could you describe this video for us, please?
Objection, leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate number on the vehicle. I believe the video was taken sometime prior to November 21st, 2020.
Okay.
Okay, I'd
Just
like to
associates him
display for
with
the
the
witness
vehicle
only,
earlier.
Exhibit 175, please.
Go ahead.
At the beginning of the day,
Please
the judge asked him
identify
what name he wanted to go by, and he
175.
again danced around that, just called himself a
This is,
third-party intervener, didn't give a name
Relevancy.
because he's an idiot.
Um, Overruled. You may answer.
This is a photo, there's two individuals in the photo. The individual on the left, I know to be the person referred to as Darrell Brooks. It displays a vehicle, a red Ford, and it has the license plate number which is displayed in the photo.
What is the source of this photo?
Objection leading.
Overruled, the
Instagram.
witness may answer.
We obtained it through social media.
Okay. I mean, this is a photo versus a video.
This is the photo taken from
Hold
a
on.
video.
I understand the objection, it's sustained, it's foundational. This particular question, the witness may answer. Go ahead.
This is
Overruled or sustain?
Overruled.
You said sustain.
What did I say?
Yes, you did.
Sorry, I meant it's overruled.
Wow.
The witness may
Even
answer.
Brooks knows his
Sorry,
objection
taking
should be
notes. I
overruled.
was writing the word source, and I think that's why I did that.
Interesting.
In any event, go ahead and answer. Sorry about that, for any confusion.
Civil
that may
procedure
cause.
expert Darrell Brooks and murderer
This is a
correcting the
screenshot
judge on her
taken
inaccurate
from a
ruling.
video.
Move to admit 175 and permission to publish, Your Honor.
Objection to that, what's the relevancy? I don't see the alleged defendant in here.
Your objection is noted, it is overruled, and Exhibit 175 is received, permission to publish is granted.
That's it. The alleged defendant.
Where's, oh, sorry.
The jury would also let me know when it's in the jury box monitors, or on the jury box monitors.
I'm going to say generally yes. At least in civil cases, you know that on a procedure basis, you may have some more work to
All right,
do,
go ahead.
but you probably are going to come out on top. You definitely should, right?
Person you know is Darrell Brooks
People
in
can be
this
pro se.
photograph?
Some are good at it,
I'll consent to being
but
called.
most of them are not. They just think they are, or they think they would be.
Overruled.
It's a technical thing.
Yes,
You
he
need to be
is.
trained to do it.
Please circle
Even if
or
they're
X
bad
or
lawyers,
mark
it doesn't
in
mean
some
you'll be
fashion.
good at it. Like fixing your own car or building your own house or anything like that.
How do you know that's Darrell Brooks there? His back is to us.
Objection leading.
Overruled.
I've watched the video in its entirety and I've seen his face in the video.
Okay, that can go down, please.
So this kind of event, this is kind of rare with this kind of mass
Detective
murder
Casey,
like this.
In total, how many
with a vehicle, it's
videos
rare.
do you think were collected by the Waukesha Police
I
Department
don't know. I
during
think
this
anything
investigation?
crazy could happen
Objection,
anywhere.
speculative.
School shooting,
Overruled.
Las Vegas
You may
shooting,
answer.
this nut murdering people. I don't think it's
We
particular to a
have
place.
at least 65 to 75 files.
I think if
Some
you
of
go to the
those
rural
files
areas like
contain multiple videos,
The
photos.
very
could
northeast,
be 10
maybe
each,
the
so
north
I
part
would
of the
say
country, that sort of thing, there's probably less
300
there
to
just because
400
less density of
videos
people.
We've collected.
What were the source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems.
The only
for
fun in this kind of
businesses that were
situation is
downtown
when they
Waukesha.
get it from social media and they have to tell
Were
what the
all of
person's
the
screen
videos that
name
were
was.
available shown to this jury?
No, they were not.
Objection leading.
Overruled. You may answer.
No, they were not.
Have you personally observed and reviewed each of the video files available in this case, sir?
Objection speculative.
Overruled. You may answer.
Yes, I have.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection leading.
Overruled. The witness may answer.
I have never seen anyone driving the vehicle besides the defendant in any of the videos that I looked at.
In any of the videos were you ever
Lincoln
able
said a
to
lot of
see
wise things.
multiple people
So whether he
inside
said it or not,
the vehicle?
Objection
there's a lot of truth in it.
Overruled. The witness may answer.
Not just from a technical aspect of
None of the
representing
videos that
yourself,
we
but
looked
controlling
at
your own
showed
emotions,
anyone
getting
else
perspective,
in the vehicle.
exchanging advice. It's bad on a lot of fronts. Sometimes appropriate.
Any of the videos
But
at
generally
any
bad.
point show the red SUV coming to a stop, a complete stop along the parade route?
Objection leading is
Oh.
speculative.
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the
It's
vehicle?
kind of leading.
Objection, leading.
Overruled, the witness may answer.
Nice, boom.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
There was testimony earlier in this case about witnesses observing multiple people running from the car. Do you remember that?
Objection, leading.
Overruled, the witness may answer.
Yes, I remember that.
Were there multiple reports like that, sir?
Initially, there were some reports like that.
I wonder if you noticed this
When
equation.
the vehicle
Getting
was
caught
found on Maple Street,
Plus
you weren't there.
evidence equals life
Correct.
sentence.
Leading.
Overruled,
See if you
his
do that
answer
math.
may stand.
Do you know what police activity occurred when the vehicle was found on Maple?
Objection, speculative. Just stated he wasn't there.
Overruled, the witness may answer. He was asked, what does he know?
Yes, I do.
Please tell the jury what happened when the SUV was found on Maple.
Objection, leading.
Overruled, the witness may answer.
This is why you can't do a witness in 20 minutes.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection, leading.
Overruled, the witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue and interviewed the people that reported the people running, our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection, leading.
Overruled, the witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
Nice.
My understanding that key was taken from Mr. Brooks when he was taken into custody and turned over to Detective Stern and Detective Carpenter.
Objection, I don't consent to being called that name for the record.
Noted, overruled.
How did you get it?
Objection, leading.
Overruled, the witness may answer.
You just stated how you got it.
Overruled, he may answer.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection, leading.
That's
Overruled.
not leading.
At that point, the vehicle was at the Waukesha County Sheriff's Department Secure Storage Facility. Mr. Johnson was over there processing the vehicle. I went there and I took the key with me and I checked the vehicle to see if the key would work in the car.
And
What did you find?
Objection, leading.
Overruled.
I found that the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Thank you. Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Objection, I don't consent to being called that name. He's leading the witness.
Overruled, foundational, the witness may answer.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection, leading.
Overruled.
Yes, I have.
Did you verify his identity by the name of Darrell Brooks?
Yes.
Objection, I don't consent to being called that name. Leading.
Overruled. The witness may answer.
Yes, I have.
How did you do that?
Objection, leading.
Overruled.
There were a couple different ways. One way is when a person is taken into custody, we take their fingerprints. We check that against other records that are kept by the state. Those fingerprints matched Darrell Brooks. I've also spoken to
Not surprising.
3 women that he has children with. They verify that is his name that he has always gone by. I have also spoken
Even
to his
foundational
mother,
questions,
which
if they're
states
leading,
that
are usually
that is
allowed.
the name that he has
But he's
gone
just
by
doing this to
always.
be disruptive. That's all he's doing. Even if you ask a leading question,
I'd like to
and
put
you're
on
the
the screen
lawyer
for
on the other side, and you know
witness
that
only exhibit
this is something that's
88.
going to come in, if they just ask another question or two, you're not going to sit there and do that
Go
over and
ahead.
over. You really shouldn't be doing it much unless you're trying to throw somebody
See
off their
exhibit
game,
88, sir?
or they
Yes,
really are
yes,
trying to
yes.
lead the witness somewhere the witness wouldn't go otherwise.
Overruled.
That's my opinion.
Go ahead.
Grounds for overrule.
Relevant.
In what way is it relevant?
In what way is it relevant? No.
2 of the counts alleged in this case. Go ahead.
Can you please identify exhibit 88, sir?
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward.
And remember, he had jumped
Date of
bail.
birth of 221.
He's a career criminal and career beater of women.
To your knowledge,
One of his
was
avocations.
Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection, leading.
Overruled. The witness may answer.
One of the things they want to do with this guy was get some certified
What
copy
is
of
the date of this
bail
bail
form.
form, please?
to support the bail
leave
jumping
it to me at
counts.
the bottom.
The date on the bottom
Objection,
is
leading.
Overruled. The witness may answer.
2/21 of 2021.
Was Mr., we'll strike that.
Strike that.
By classification, can you tell us the level of charges that Mr. Brooks was pending on for this
Objection.
bail?
Leading.
Objection. You've already made a ruling on it.
Oh, okay.
Overruled. The witness may answer.
That was kind of a fresh objection,
All the charges that I see on here are felonies.
of course.
To your knowledge, was this bail in full force and effect on November 21 of 2021, sir?
Objection.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
Objection, leading.
Overruled.
Yes, I do.
And I'm looking under paragraph B, the 3rd bullet. Do you see that?
Yes, I do.
Could you please read that bail condition to the jury?
Objection, leading.
Twitter is popping
Overruled.
this
The
morning.
witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to
Kinda
admit
did
number
that,
88, Your Honor.
Objection.
Exhibit 88 is received.
I'd like to display for
It was
the,
already speculated to. How's that coming into evidence?
Overruled. And permission to publish.
I'm sorry, I did not seek to publish this, Your
Oh,
Honor.
all right. Turn that
I
on.
request a legal finding of fact for that.
No.
The objection is noted. It's overruled. Continue. Attorney Opper.
Thank you. I'd like to display for the witness only Exhibit 89.
This may be about it for this guy from the DA.
Go ahead.
Sir, can you please identify 89?
Objection.
He stared at me, waited till he stopped staring at him, and then
Overruled.
objected.
This is a,
This has been stipulated to as well. How's it evidence? How's it being admitted?
The objection's noted.
Just
It's
because they stipulate
overruled.
something
The
as
witness
evidence
may
doesn't
answer.
mean it's not
Request a
evidence.
legal finding of fact for that too, Your Honor.
Noted. Overruled. Go ahead.
this is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks with the date of birth of 2/21 of 1982.
Is this a different case than what was displayed in Exhibit 88?
Objection leading.
Overruled.
Yes, it is.
Are you able to make any observations about the level of charges related to this case, sir?
Objection leading.
Overruled.
It appears that there's 4 charges, 2 of which are felonies.
Okay.
Wow.
And on the bottom of the form, can you tell the date that this bail was issued?
Objection leading.
Overruled.
States 11/11 of 2021.
The, directing your attention again to that same location in the middle of the page under paragraph B, the 3rd bullet. Could you please read the conditions of release that were set by the court in that case?
Don't kill people. That's
Overruled.
probably
The
one of
witness
them.
may answer.
Probably a
Defendant shall
condition.
not commit any crime.
To your knowledge, sir, was this bail in full force and effect on November 21 of 21?
Objection speculative and leading.
Overruled as to both. The witness may answer.
Yes, it was.
Finally, sir, I'd like to
The word finally has
put up
been
one
uttered.
last item for you, or 2 items. 1 second, please.
But remember, when an attorney is on their final point, they can then divide it into sub-points.
I'd like to display for the witness only Exhibit 13.
Not in theory.
Objection, what's the relevancy of this? How does it save any foundation to?
But this guy's testing the theoretical physics limits
How?
in the known universe.
Give the state some leeway to establish that. Go ahead.
Thank you. Sir, do you recognize can you tell if Exhibit 13 is a video, sir?
Yes,
Now, if it
is.
were an attorney behaving
Have
like
you
he's
seen this
behaving
video
with the
before?
objections and the constant saying this isn't my name or whatever,
Still relevancy.
there would be a riot act going on by the judge. He's
State
given much
is
more leeway.
Asking the foundational
representing
questions.
himself.
The objection's a bit premature. I'll take it under advisement. Go ahead, Attorney Opper.
Yes, I have.
What does this video depict?
Objection leading.
Overruled. The witness may answer.
Objection speculative.
Overruled. Go ahead.
This video depicts the backyard at 4014
The backyard?
North 19th Street in the city of
I could never
Milwaukee.
sneak into Wisconsin and get away with anything.
That's the address of Dawn Woods, the mother of Darrell Brooks. And on the lower left-hand corner, you can see a Ford Escape.
In the lower
Objection.
right,
I move to strike that. How does he know?
Move to strike it.
The objection's noted. Overruled. You can ask him on cross-examination.
Yeah.
You can question him about that. Go ahead.
in the bottom right-hand corner of the exhibit, do you see a date and time stamp for this video, sir?
Objection leading.
Overruled.
Yes, I do.
What does it say?
It says 11/21-2021, and then it says 13.
The Ford Escape didn't really work out for him. The Ford got caught.
What do those numbers represent, sir?
Objection leading.
Overruled.
To me, it mean that the video was taken on November 21st, 2021 at 1:26 p.m.
And do you believe this video is a true and accurate representation of the events of that afternoon at that location, sir?
Objection speculative.
Sustained, if you could lay a little more foundation.
Sure.
please.
How did you come into possession of this video, sir?
The defendant's mother provided it to us.
Boom.
And do you know approximately when it was obtained?
Objection speculative.
Overruled.
The evening of November 21st, 2021.
Do you know if the defendant's mother was cooperative with police in providing the video?
Objection relevancy.
Overruled. The witness may answer.
Yes, she was.
Do you know if the video was provided to police when asked?
Objection leading.
Overruled.
Yes, it was.
Do you have any reason to believe that the video was altered or modified in any way before it was provided to police?
I do not.
Move to admit 13, Your Honor, and permission to publish.
Objection. With relevancy.
Noted, overruled. Exhibit 13 is received. Permission to publish is granted.
Objection,
For the
where's the
record, this is
relevancy?
a video, it's 49 seconds in duration. We're going to play it in full. There is no audio, and it will be played at normal speed.
I generally completely agree with this.
Oh,
I believe
hang
he
on.
would like to kill the judge.
Yes,
He
let
looked that
the
way
jurors will let
yesterday.
me know when
Of course, he
the
has a habit
monitors
and history
are
of beating women, and
displaying.
if you watch his interrogation with the police, he tries to bro out with them about how
Go ahead.
terrible girlfriends are and they should go to jail for accusing people and how did she do this to him. And of course, she was somebody who he had, I think, more than once physically assaulted. It's an interesting theory there. I guess it depends to some degree because some judges will sustain more or less, even if they should or shouldn't. And some attorneys make more objectionable questions than others do. So it's kind of hard to say. Typically speaking, people don't get out of control on that. That's just this guy being this way. I mean, one of the things you don't want to do is annoy the judge, right? So if you are overruled 50 times in a row, maybe you need to recalibrate, go back and reread your evidence manual, figure out what's going on.
Detective Casey, were you able to see any emblem on the front grille of that vehicle as it drove away?
I would have to look at it again.
Okay, I'm sorry. Let me ask you this. Did you see any damage to the front end of that vehicle as it drove away?
Objection leading.
Overruled.
I did not.
Okay. I'm going to put up State's Exhibit 14 now, please.
Go ahead.
So
Just to
the mom
the-
gave the video over of
Yeah,
him
just to the
taking the
witness,
truck,
please.
Thank you.
or as they call it in Wisconsin, a car.
Do you recognize Exhibit 14, sir?
Yes, I do.
What is the source of Exhibit 14?
This is a still shot taken from the video.
The same video we just saw, number 13.
Yes.
Okay.
I think I recall in her most
Move to
recent
admit
interview
14
that
and
she
permission
says,
to
look,
publish
he's
on it."
mentally ill.
Relevancy.
He should be on some kind of medication. He's
The
not.
objection's
Needs
overruled.
help,
Exhibit
etc. But she
14
also
is
thought that
received.
he should
Permission to
receive
publish is granted.
some level of punishment for what he's done. So I think that's what she said. She also was the one who talked about how he wanted to
Sir, do you
delay
see
the
Darrell
trial,
Brooks in
and she
this
told him, "You're not going to be able to
photograph?
do
Objection. I don't consent to being called that name again for the record.
Noted. Overruled.
that." How frustrating it must be to be called the name you
Yes, I
gave the
do.
police, and is actually
you
your name
identify or, excuse me,
on the trial
excuse
for
me,
you for having murdered
describe
innocent people.
the clothing items
He's
that
got a
you
great
see
point
him
there.
wearing in this photograph? Oh, it's not in the jury box yet, I'm sorry.
You can state your objection, though.
Leading.
Overruled. The witness may answer.
And of course, he's taking his mother's vehicle, which he destroyed.
Mr. Brooks is wearing a red t-shirt, blue jeans, and he has blue-colored flip-flops on with white
This
socks.
wouldn't surprise me. He was exploiting her even then, taking her vehicle. He didn't have his own.
What's the
Complete
date
loser.
and time stamp for this photograph,
When he yelled at the
please?
judge yesterday, he said, "I'm a grown man. I got grown children. You don't tell me what to do." What an accomplishment that your children are grown. That's you really did something there.
And that's what time, sir?
Objection leading.
In, on the 12-hour clock.
Objection leading.
Overruled.
That would be 1:26 p.m.
All right, thank you. Have any other questions, sir?
All right. So they're going to see it. He's going to CX this guy, and then maybe a little bit of redirect, and then
We cross.
the critical moment comes where he will tell potentially what he thinks his case is, other than he doesn't like the name they call
Just
him.
watch 13 and 14. Do you see anyone driving the vehicle?
No, I do not.
Do you know if anyone's in the vehicle at the time that you see it pull away?
Yeah.
I would assume, based on my training experience, that when the vehicle pulled away, that there was someone inside the vehicle, because in order to move a vehicle, you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question.
It was
Do
the
you
question.
see anyone in the vehicle?
I object, Your Honor, that was the question, and he's already asked and answered. The question is, anyone can be seen.
The objections, not sure what the objection was, but the answer may stand. You can ask your next question.
Let's go back to Exhibit 175. You pull that up for the witness.
I guess his theory is
State,
maybe there was
please pull
another
that up.
driver or something stupid like that. Even though there's, of course, video of him driving it
Witness only or published?
as it's hitting people.
Publish.
Okay, thank you. Go ahead. Jurors, let me know when it's in the jury box as well.
And how do you know that's me at that precise moment? I like when he says that. There's a video of him doing a thing, and when he turns away for a moment during the video, he likes to take a picture and go, how do you know that's me? Object permanence.
All right,
Just-
go ahead. It's in the jury
You
box.
just testified that this was the alleged defendant. How do you know that?
Look at the other guy
Can you
holding
see
the
a
gat
face?
there in his right
Which
hand.
question are you asking? Those were two.
Can you see the face on the circled individual in that exhibit?
In this clip, I cannot see the face of the person that is circled.
It's hard to tell what kind of gun he's got there. I mean, likely a Glock. But since it's the same color
I can
as
tell who
outfit,
that is because I have
the
watched
slide looks
this
kinda long,
video
can't
in its
tell.
entirety, and I can tell that it is you based on all of my contacts with you.
boom.
So why were there not any other exhibits that can
Because he wanted to get the
give
license plate in
credibility
him.
to you positively identifying the individual in this video?
Objection argumentative,
Grounds.
compound.
Sustained as to the form of the question.
Is it fair to say that this is the only exhibit photo from the video?
Yeah.
Go
Can
ahead.
you clarify the only one that is shown today, or the only one that has ever been taken?
The only one
that
that's,
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is the only one that we've shown today.
And you can tell just from this exhibit exactly who
There
that
you go, there.
individual is.
I don't believe that was my testimony.
It was not. It was,
I'm
I
asking
watched
the
the whole
question.
video and know who you are.
From just looking at this,
Say yes.
no.
He
But I
should
know
say
from
yes.
looking at the entire video.
That's not my
that
question.
it's
My
you.
question is, if you pretend it's not me, is it then
We're
not
talking
me?
about this exhibit that's being shown right now during your testimony right now at this moment.
Just say yes. I know it's you.
Strictly that.
Could you ask your question, please?
I'm going to object, asked and answered.
Sustained as to the form of the question as well.
This is one of his
Would it be
tactics.
fair to say that from this exhibit 175 that they're
If
looking
you
at
ignore
right
what
now,
you
that
know,
you
do you
cannot
then
tell
not know it?
who the circle individual is? Would that be fair to say?
That would be fair to say.
Can you clear the circle?
Well, I don't think he's
Thank you,
fooling
Madam.
anybody of any merit.
And do you recall what date you viewed this video, as you call it?
I have viewed this video multiple times. I don't recall the specific dates that I've seen it.
Was it relatively early on in the investigation?
There have been multiple times that I've watched this video, some of them early, some of them as late as yesterday.
Do you recall seeing this video the same night of the incident or in the days following?
Same
I did
night.
not see it the night of,
Yeah.
but it would be the days following that I have seen it.
And at that time, did you have knowledge of who that vehicle belonged to?
Yes, I did.
And did you have knowledge of
Whose gun
the
that was?
usage of that video? I mean, the usage of that vehicle?
To carry somebody around that was
I'm not
holding
sure
a
that I
gun?
understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Sustained as to the form of the question, if you could limit or perhaps direct him to a specific time frame regarding the use of the vehicle.
Yeah, for
At the
example,
time
you
of the
used it to
incident.
kill people. Just one example.
Yes.
And what, and can you clear that? And what information was that?
The information that I had is at the night of the incident that you, Darrell Brooks, were the person that were operating the vehicle.
Boom.
And who did you learn that from? And for the record, I don't consent to that name.
Noted,
For the record.
overruled. Go ahead and answer.
Can you repeat your question, please?
Nice.
I'm gonna go another route on this.
You done with the exhibit, sir?
No, I'm not.
Yeah,
Chairman,
leave that
Crowley,
one
your
up there.
question?
And that
Yeah,
makes you
I'm
look
going
good.
Another route.
All right, thank you.
Going another route.
You just
Should have done that the day of the
testified to
parade.
seeing
Yeah.
the entire video that this steel frame exhibit came from, correct?
I testified that this came from the entire video, correct?
You said that you viewed the video in its entirety, correct?
The entirety what we recovered from your social media account. I'm not sure if there is a longer version someplace, but
Did you see the video in its entirety? The video that this exhibit came from?
yes.
And are these the only two individuals that you observed in that video?
They are the only two that I recall seeing in the video.
Did you ever inquire about the identity of this individual?
No, I have not.
Can you clear that circle?
Thank you, Madam Clerk.
Would it be fair to say that from looking strictly at the exhibit that we're viewing right now, that both individuals have the same hairstyle?
What the hell has that got to do with anything?
It would be fair to say.
Can we clear the X's and clear the exhibit?
Go ahead. Thank you.
So there you go. You have the same hairstyle. Reasonable doubt.
We go back to exhibit 13.
I mean, maybe his opening statement will be, they didn't prove it was me. I don't know.
Go ahead.
We'll know soon as he's done
Statement
with
assist,
this
please.
stupid cross-examination.
13. Can you play it? Well, just play it. I'll tell you when to pause if that's okay.
Go ahead.
Please isn't a word he likes to use.
It's not up yet.
Oh, thank you. We're gonna wait until it's in the jury box.
Oh.
Yeah, this is
Okay, go ahead. Thank
hard to
you.
avoid with the system we have with the right to represent yourself. So
Just a reminder, it's 49 seconds long.
I don't think I'm gonna need the.
it is
Well, I don't
nasty,
know.
but
Like,
it's one of the many things we have that
Pause.
are.
right there, the individual that you observe,
That's you.
right here. Do you see them wearing a hoodie?
The person in that photo is not wearing a hoodie.
Do you see a hoodie anywhere present in this video?
No, I don't see a video or a hoodie anywhere in the video.
Can you take the X down? From this angle, it'd be fair to say that you can see the very front end of a vehicle, correct?
That is correct.
Can you see any windows or see inside the vehicle at that time? Or at the time that we're looking at right now?
You cannot see inside the vehicle at this time.
So it would be fair to say that just by looking at what we're looking at now, you wouldn't know if anyone's already inside the vehicle.
This has been asked and answered, Your Honor.
I'll allow it, the witness may answer.
This is a whole different.
I'm allowing it. Go ahead.
That is correct. From this video, you cannot tell if anyone else is inside the vehicle.
So it'd be fair to say that you're not sure.
It's fair to say that I am not sure.
Can
So
we
I
pull
guess
this
he's
down?
going to go with his theory that someone else drove it. Stupid.
Whoa, wait. I'm sorry. Can you pull that back up for 1 second?
Same exhibit.
Same
Go ahead.
exhibit, 13.
All right.
I think one of the things this
Stay
does do is
Put that back
Right.
on display.
It doesn't-
there's an element of entertainment in how dumb he is, but
Do you want any more of a plate or just the still?
We wait for
sometimes in
the
these
jury or do
trials,
they-
the person just sits there in a suit, which they wouldn't normally
No,
wear
we don't
because they're
need a
normally out
plate.
murdering people, and they don't want to ruin a suit
Need
doing
to
that.
get to go to a certain point?
That
Yes.
you can,
All right.
if
Do
you
know
watch
what
enough
one?
of this guy,
I'm
see that
about
he
to-
is heartless, that he has no concern, compassion, empathy, nothing
Looking
for
at
anybody
this
he's hurt, not the
house
people
right
he
here.
killed, not the people he injured,
see an
not the women
address
he's beaten.
posted anywhere on
You
this
can
house?
see that he's completely self-absorbed, and you get
In
a
the photo
picture
that you
of just how
circled,
lousy
no.
a person he is, and you don't
So
normally
it'd be fair to say
get
that
that
you
when
don't
they
know
sit
the
there
address of
silent,
this-
except through the
this house.
testimony of other people.
That is incorrect.
You just said that you don't see an address posted anywhere in this house. So from the vehicle,
So even though you know the address, if
Still
you just
looking
looked
at
at
the
this,
corner
could you
right here.
pretend you don't know it? So dumb,
from the video that we're viewing right now,
right?
do you see an address posted anywhere on this house?
I do not see an address posted in this photo.
So judging by this, well, actually it's a video, but
Right.
judging by this video, how can you
God.
know the address of this house?
Because I've been at this house before to talk with your mother. I've seen the address on the front of the house.
Judging by this
Hold
video,
on, you have to let him finish.
Yeah,
because that
exactly.
was
You
not
don't
the
have to
question
judge
you
it
asked.
just
You
by
asked
the
him
video.
how
That's
he knew.
stupid.
He can answer.
He can say what he knows. How do you know you're on planet Earth? How do you know that's
I've
not in
been at this
Argentina?
address before.
Stupid.
I have spoken to your mother. I have been in the backyard of the residence. I've seen the address on the front of the house. I know this to be your mother's house. I recognize from this photo to be your mother's address at 4014 North
Nice.
19th Street.
He doesn't have to
recognize the
pretend
house
he
or the
doesn't know
address?
things.
Because we don't see an address in this video.
Who cares?
I recognize this house to be that address from being there.
And had you already been there, as you say, and talked to people, as you say, before you viewed this
As you
video?
say.
I believe that I saw the video first, and then I was at the address.
So at the time that you saw this video, you didn't know whose house that was?
That would be an incorrect statement.
Yeah, he knew whose house it
You
was.
just
He
said
just
that
hadn't
you
been
saw
there.
the video first before going to the house. Did
Doesn't mean he
or did
doesn't
you
know
not
whose
say that?
house it is.
That'd be fair to say.
I guess I'm a little confused in your question.
Because it's
We
stupid.
received the video. We know from getting it from my mother that she said that that is
Her house.
where she lives.
And that
So I
address.
knew that this was where she lives when I watched the video. That was clarified for
I
you.
follow you, but that clarification.
But if
was
we don't
stated.
see the mother in the video, how do we know he ever had a mother? Right?
That's
Darrell?
fair
Yeah.
from the clarification
Yeah.
of how you just
It's
clarified.
fair.
it.
It's
Can you
fair.
Clear the
You're
circle,
done with this,
please.
this exhibit?
How do you know this vehicle has tires on the back of it?
Yeah.
All right, we'll take it down, thank you.
How do you know there is a rear of the vehicle? You can't see it in this still shot.
You made reference to the key being found.
Mm-hmm.
Did you yourself find that key?
No, I did not.
Were you at the scene where the key was found at the time it was found?
No.
No, I was not.
So it'd be fair to say that You were told that a key was found.
Yes, I was told that a key was found.
So it'd be fair to say that you went off of what you were told. You actually didn't observe this with your own eyes.
It's a good point. There's no way to
What I'm
know it.
speaking of.
The key being found.
That's correct. I was told by two officers who I've worked with for a long time, and I trust what they tell me to be accurate.
How do you know this key wasn't forged in the fires of Mordor? No, I agree.
You made
There's
reference
entertainment. It's in
to
how stupid this guy
there
is,
being
but the
a couple-
primary
was the word
thing
you
being
used, a
shown
couple
here
ways to
is what a
identify
lousy person this
individuals.
murderer is.
You stated that you had spoken with the mothers of the alleged defendant's children. That'd be fair to say?
I believe I said I spoke with the mother of 3 of your children.
At that time, was the alleged defendant already in custody?
Yes, he was.
Wouldn't it have been easier to just use the
Easier.
fingerprints that were already obtained?
Like I said before, the fingerprints was one way. We also verified it talking to his family members that his identity.
Any reason why, or let me back up. Is it fair to say that there was more confirmation needed to identify the alleged defendant at that point, seeing as how the fingerprints were already obtained?
We were just being thorough. We were certain that it was Darrell Brooks that we had in custody based on his fingerprints and other information that we had. It was just a matter of being thorough and verifying the person that we had and the name that he goes by.
Yep. Nice. He slipped that one in there. The name he goes by.
It'd be fair to say fingerprints are pretty accurate, though, correct? Would that be fair to say?
Yeah, that's how we know
I
it's
think
you.
that would be fair to say.
Thank you.
So it would also be fair to say that there wouldn't be any reason why
No.
the alleged defendant that was in custody would be someone else. Wouldn't that be fair to say?
Objection, that's compound and
Asked
difficult
and
to
answered.
follow.
It's
And-
not compound. It's
Sustained
not
as to the
difficult to
form
follow.
of the question, sir, please
That was
rephrase.
very clear.
Sustained as to the form of the question.
And where did the interviewing of the mothers of these children take place, if you recall?
I spoke to Jessica Macklin in Iowa at her residence. I spoke to Angel Fitzpatrick at her residence in Menominee
Whoa, 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 whoa,
Falls.
whoa, whoa, whoa. Can we strike that? Why do the names?
I don't think
Have
that's
to be
accurate.
stated.
Overruled, he was answering
I
the
don't.
question.
I didn't see that in the procedure. So the normal situation
His
is
answer may stand, your
prosecution
question
gives
is
a
denied,
closing
and the witness may
argument
continue
first.
answering.
then the defendant gives
Spoke
a
to Angel
closing argument,
Fitzpatrick in
and then
Menominee Falls at her
because
residence, and I spoke
the
to
prosecution
Erica
has the burden
Patterson
of proof,
a number
they
of
get to
times,
close after that.
um,
I actually looked up a
at
statute on
various
it.
locations about you.
See where I took it. Maybe I took it on the
You
iPad.
said
Show you
one of
what
the
I'm
mothers
talking
of
about.
these children you spoke to in Iowa.
It shouldn't matter that
Correct.
he's representing himself in theory. Of course, every
Why would
state
you
can
go
have its
all the way
own
to Iowa?
law.
Because initially you listed her as a witness on your witness list for court.
So under Wisconsin
So we went
statute
there and we wanted to
972
verify what information she might have that
10,
she would testify
in
to.
closing argument, the state on the issue of guilt
Just for the record,
shall commence and may conclude the
I
argument.
don't recall
Defendant on
listing
the issue of
anyone
mental
as a
responsibility
witness.
shall commence
Just for the
and
record.
may conclude
For
the
the
argument.
record, Mr. Brooks, you can't testify.
I didn't see anything
At
about
this moment, you'll have an
representing himself
opportunity
as
should you
changing that,
choose.
unless I missed
I
it.
just
but-
wanted that clear for the record since what was
Can't be,
said.
it's struck from the record at this
I-
point because you're attempting to testify.
I'm
The
not
jury will
attempting to
disregard
testify. I
that.
just wanted the record to show
The
that I
jury
had no
will
knowledge of doing that.
What you
The
have
jury will
knowledge of is
disregard
testimony.
those statements made by the defendant,
If something's-
that he is not testifying, and it would be improper at this time for the court to receive them.
I don't think a
Go-
record should be
next
made of
question, sir.
something that I didn't do.
Next question or close
Next
it down.
question, sir.
It's ridiculous. So you said you went to Iowa to,
So remember, his attorneys
try
would
to
not be
find
allowed
out
to
what he
behave this way.
testified
So
to.
he's able to
Why?
treat the judge this way by
Objection,
representing himself and giving us
argumentative,
extra
irrelevant,
leeway.
calls for hearsay.
grounds.
Sustained as to all basis. Next
It's
question.
always good to yield grounds after the grounds are given or while they're being given.
Was that an attempt to prepare for what might have been said?
I'll allow that.
Okay.
Go ahead.
Yes.
Why would there be preparation involved in someone who might testify on an alleged defendant's behalf?
Objection, argumentative.
Grounds.
Overruled, I'll allow it.
We went there to speak with her, so if she came in and testified, there wouldn't be any surprises. We also wanted to find out if there's any background information that she had about Mr. Brooks that would be helpful in our investigation.
So you made reference to not being any surprises.
He's starting to smoke.
Would it be fair to say that there was a little worry there?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
What surprises were you referring to? What do you mean by surprises? No surprises.
Your Honor, I object to this entire line of questioning. This witness is not expected to testify. It's wholly irrelevant.
Well, he opened the door by
Always
putting
learning a
the
new
name on
phrase.
record and saying
Open the
what he-
door.
I will allow one more question on this. Go ahead, you may answer.
Could you re-ask the question, please?
What do you mean by making sure that there were no surprises?
We wanted to make sure that there wasn't any information that we weren't aware of that may come up later that would be helpful in the trial.
Do you recall making an attempt to interview the child
Objection, relevance.
who was 7 at the time?
Sustained as to, next question, please.
That's classic.
Reason for the sustain, Your Honor?
Little spinning
Not
circle on his head.
Well, the question was asked, does he recall?
Sustained, next question, please.
If you have
Grounds for
one.
the sustain again?
Relevant.
How is it not relevant?
Keep going, sir.
Yeah.
Did you interview the child?
Same objection.
Grounds.
Sustained.
Grounds for the sustain?
Relevant.
Why would you ask to interview the child?
Your Honor, objection. This
Sustained.
entire line of questioning is inappropriate.
Sustained. Move on.
I would
Mr. Brooks.
object that trying to interview a 7-year-old child is,
Sir, move on, please. 90611. It's also not relevant. Assumes
Very
facts not in
relevant.
evidence.
it was a tricky move.
So this is the last state
You made
witness,
reference to,
last exam,
in
and
regards to exhibit.
he's being allowed to get away with
88
these
and
extra
89.
comments and things like that because this is so close to the end of the state's case. Otherwise, I think
Which
she
were
would
documents
kick
from
him out.
an entirely different county. Do you work for Milwaukee County?
Yeah, I don't think he can deal with not being able to control or intimidate or push
No,
people
you're not.
around, and he's frustrated by that. He thinks he's better at this than he is. So I agree this doesn't help him with a jury. It is the rare look at the actual
So
direct
how did
behavior of
Milwaukee
a
County,
murdering
which is a different
narcissist
county, come
sociopath like
into
this guy that the
your
jury is able to see. They're
investigation
normally
in
hidden behind
Waukesha
counsel,
County?
as counsel should do for them. This is exactly correct. He
May
was
answer.
he had to
With the
push for
understanding
this.
there are some
He had to push
limited
for this.
Pretrial rulings that still are in
He
play.
was told the consequences of this. He was told he'd be on his own. There wouldn't be lawyers for him. He doesn't want lawyers, right? He wants to do what he's doing. This is what he wants to
Started off
do.
by saying in regards to Exhibit 88 and 89. That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial rulings.
Okay.
During the normal course of an investigation, we do background on a person to see if they have any open cases or any information that would be helpful. There is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
Nice.
And in reference to having charges in one county,
This may be the one time where he doesn't get to close a witness with asking stupid questions about the
And
plaintiff. And do you see the
potentially
state of
charged
Wisconsin in the room with us right now?
reference to that.
Because he already did that, I think. But if I beat a woman in one county, why would you care in this other county? What kind of world are we living in?
Wouldn't you essentially have to violate the conditions in one county
Right.
and strictly be charged in that county?
Yeah, if I'm committing a crime
That was
over
an
here, why
inaccurate
would you care?
statement.
You being in law enforcement for a very long time,
Mm-hmm.
it would be fair to say that you're familiar with the term double jeopardy, right?
Oh, Lord.
I've heard the term before.
And what is your understanding of what that term means?
Objection, irrelevant, beyond the
Grounds.
scope of the witness's knowledge, legal conclusion.
Sustained
Me
for all
too.
those reasons.
Me too. There's nothing in this guy
So when did you become
that has
the lead
any concern for
investigator
what he
in this-
did. For whatever reason, he did do it.
That was about 8:30 p.m. on November 21st, 2021.
So same night.
Correct.
And whom were you made lead investigator by?
The command staff or Lieutenant Jerry Habanik.
Do you recall why you were tapped to be the lead investigator?
Because you
I was the
murdered a
most
lot of
qualified
people
person, had the most experience to take care of it.
and they needed an investigator.
That's what I've been told.
That's a
Any
little
other reasons
humility
besides
there.
that?
Also because I was at the parade route a little bit earlier and I had the most information out of anyone. It took a little while for the other staff to come in, so I already had a little bit of a head start with the information that I already had learned as being there at the beginning.
And that would be in the information that you said you had more knowledge of than anyone else at that time. Would that be in reference to having an interaction with the vehicle at some point?
I would say as the totality of the situation.
Nice.
I was there when the car first went through. I know what the radio traffic was for taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the case. I was also on scene downtown and took control of the crime scene initially. So a lot of those things decisions were made even before our command staff started coming in to take over lead on the case.
When you referenced, you were there at the beginning when the vehicle first entered in the parade. What do you recall about when the vehicle first entered the parade?
I remember a horn beeping, red Ford Escape driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Nice.
Driving into you, what do you mean?
I meant that I was in front of your vehicle contacted me, pushed me off to the side, and continued driving without stopping.
Were you injured in this incident?
I was not injured, thankfully.
And you made reference to a horn beeping. What do you mean a horn beeping?
I mean,
You
a
mean
horn.
the vehicle was beeping its horn?
Yes, the vehicle was beeping its horn.
What would be the only time a vehicle would beep their horn?
Objection,
Yeah, that's
speculation.
stupid. Grounds.
Sustained.
Grounds.
Calls for
Reason.
speculation.
Lots of reasons to beep it. See, here's one I don't know if he's going to go with the vehicle was out of control and I was beeping the
Do you
horn
know
because I
why
didn't want to
you-
hurt people.
Why the
Stupid.
vehicle was beeping their horn?
Same objection, Your Honor.
Do you know why you would beep
He
your
asked,
horn?
do you know why? So he can answer that question.
Just
Could you repeat the question, please?
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
nice. You asked
And how did you come to that determination?
because you went on to
I've
kill
been driving a
everyone.
long time, and a lot of times people get angry, they're late, they beep their horn at you in a way that is because they're upset and they're trying to get past you.
He didn't get what he wanted out of this.
Do you know that for sure?
He
You
said he
asked me my
imagined.
opinion.
Right.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you
Yeah.
observed was in fact angry?
Yeah, he just got dunked on deservedly.
I assume that he was.
So it'd be fair to say you don't know for sure.
I do not know for sure, but that is my opinion, is that he was angry.
And at that time, you had no knowledge who the driver was. Would that be fair to say?
Well, I had knowledge because I saw your face. I did not know your name
Did
at
you
that
know
time.
who the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you
Oh.
had any conversations
Thanks.
with him, talked to him?
Hold
saw
on,
him?
compound question, ask one.
I was just giving
Master linguist,
clarification of no.
Darrell
what I
Brooks.
meant by
It's a
no.
Explaining
compound question.
The meaning of
Please
basic
rephrase.
words to the witness and judge.
Before you observed this vehicle, as you say, and this driver that, as you say,
As you
did
say, there's a
know him?
driver.
I have no memory of meeting Mr. Brooks before that.
Another
afternoon.
dunk.
So it'd be fair to say that you're assuming something that you don't know. Would that be fair to
No,
say?
that's stupid.
Objection, compound.
And
vague,
stupid. Look at the middle DA.
argumentative.
That's everybody.
Grounds.
Sustained as to the form of the question.
Because it's dumb. I wish that were in the
How would you
rules
know
of
how
evidence.
someone's feeling if you don't know who they are?
Your Honor, he opened the door to this. It's asked and answered. The
Yeah.
witness has given his opinion. It's clear.
Grounds,
I object. Improper question.
grounds.
That is the grounds.
I will allow the witness to answer why he came to that conclusion. Go ahead.
Because I beat on the hood of your car and you kept going
Like I said
and
before,
sped
I've
up
been
at the
driving
crowd
a
of
long
innocent
time,
children.
and a lot of times when people are beeping their horns, it's because they're late, they're angry at something happened, and that's why I concluded that the person was probably angry.
Dude, you got
So
dunked
it'd be-
on. The ref's not going to call a
Would
charge.
it be
Get
fair
over
to
it.
say that another reason why a vehicle would
No.
beep its horn would be to alert people to the presence?
Objection,
Grounds,
irrelevant,
And speculation.
grounds.
I'll allow it.
Come on,
Based
Judge.
upon his training and experience, he may answer.
It's a possibility.
Go ahead and push it further. Go ahead.
Did you
Go ahead.
hear
Push
this
it.
beeping before the vehicle approached you?
Yes, I did.
This guy is just awful.
You made reference to, and I'm referring to the ring video obtained in exhibits 88, or I'm sorry,
Another
The-
possibility for beeping a horn.
ring video obtained.
Could have been
in
beeping out our
exhibits
Morse code
13 and
message as
14.
well.
You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall saying that.
So
And
crux
would it
moment in
be
the trial
fair to say
occurs when
that
this guy finishes, because that's
you
when they'll
yourself
rest. And we'll get this opening statement and see just how
been
bonkers
present
this
for
guy's
all
going to be.
testimony? Would that be fair to say?
That is not correct.
How so?
I was sick one day and I was not here.
Well, I'm referring to,
Well-
let me clarify. Maybe I wasn't clear enough.
You probably weren't.
Pertaining to all testimony since trial began, you've been present for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall
She's doing her best,
testimony?
in my opinion, again, to give a fair trial and also to not create a situation, because he will appeal after he's convicted and probably will find somebody misguided enough to help him with it.
And I'm referring
Look
to,
for any little thing
so
that they
clear
could
for the
use
record,
against the judge here. So
Exhibits
she's trying
13
to avoid
ring footage
creating
that was obtained
a ground for appeal and also to give him a fair trial.
the
So she's
owner
doing both.
of 4014 North 19th Street that you testified to obtaining the ring footage the same night. Were you aware that? Well, let me back up just a little bit.
This is the world's
How were
longest
you
question.
able to obtain that ring footage?
There was officers that went to Freighter Hospital where Dawn Woods, Mr. Brooks's mother, was working. They spoke to her, and she's the one that alerted to them that she had Ring video at the house and offered to remotely download that video for them.
Boom.
And were you there yourself?
I was not there myself.
How do you know there's a hospital then? Or that I even have a mother? Darrell Brooks philosophy.
When did you yourself speak to the owner of that home?
The last time that I spoke to Dawn Woods was on August 8th
When
of
did
this
you
year.
yourself speak
I
to?
may have spoken to her a few times.
Not you,
Before that,
someone
I don't
else.
recall the exact dates.
I'm referring to the first time that you spoke.
I don't
The
recall
very
the,
first time.
I don't recall the first date when that was.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds?
Sustained, hearsay.
He's dragged this out to no
The
discernible
August
benefit.
8th date that you referred to, was that in any way follow-up? Was that follow-up investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this investigation.
Yeah. He gets exasperated when someone doesn't give him an
The
answer.
investigation
But he never answers the
continues
question
every
directly.
day. It will not end until this trial is over.
Yeah, they could find new information right now.
So what follow-up was needed at the time of the August 8th interview? I'm guessing that's what you would call it. I don't know, I'm not sure.
Objection still calls for hearsay, Your Honor.
Sustained.
Why did you need to talk to Ms. Woods multiple times?
Because every time we spoke to her, we got different information, and at that time, we were following up with your niece and nephew of what their testimony would be in this case.
He's got some ridiculous tattoos on his hands too that spell out something.
What testimony
Pretty
are
dumb.
you referring to? Because I don't recall any nieces or nephews testifying.
I'm in North Carolina, and I don't do criminal law,
I don't think I'm allowed to
civil
say.
stuff.
I think this line of questioning is irrelevant, Your Honor.
I'll sustain the objection, and at an appropriate break, I can address it further if need be. Please move on to a new topic, sir.
Remember, he actually
Made
hit this
reference
detective
to,
with his truck.
People who were injured at the parade inadvertently. You recall that?
Yes, I do.
To your knowledge, were any of those charged?
My testimony before is that those people's cases were not charged.
Remember, he's
Were they
facing
seen
like
as
70
victims?
some charges, I think.
Going to object to the form of that question. I think it calls for a legal conclusion, Your Honor.
It does not. I asked to his knowledge.
I'll sustain the objection as to the form of the question, if you could please rephrase.
I don't know how much more he could have to ask about. Last witness for the state.
I'm gonna go a different route.
It's going a different route. Poor choice of wording for a case like this. I think that white machine behind the DAs is one of the purifiers they brought in, probably. Yeah, the Manson coverage is interesting. Got more interesting to me than I thought it would. And there are some significant things going on in the case, but the rulings just haven't come down, at least as of yesterday. There's, I think, 3 rulings stacked up in the Bianco case. And some protective order in the
Do you
Wood
recall
Gore case that I haven't seen either.
Serving
Just showed up on the docket.
warrant
Have to look again
to
and
the
see if that's
Waukesha County
public.
Jail on July 1st of 2022.
Yes, I do.
Do you recall what that was for?
Yes, I do.
And what was that for? Can you state for the record and for the jury?
It's for Mr. Brooks's jail cell.
He thought a long time before he asked this.
And
so I
why
hope
did you
it's
serve a
the end
warrant
of what he's going to do?
for a jail cell?
Your Honor, I object pursuant to legal rulings previously issued in this case. I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up at a later point if need be.
What was the warrant pursuant to?
I sustain the objection. Next topic, please.
He did answer.
I sustain the state's objection. I'm directing him not to answer. We'll take it up separately.
He's so disappointed in this
Continue with
judge.
your
So
cross-exam, and I'll
disappointed.
take it up later.
So will Manson trial be televised? The federal cases, they won't be. They don't televise those. The state cases could be. That's a potential, but let's see if I can remember them all right now. The Walters case is on appeal. That'll probably come back. The Wood Gore case, in my opinion, will go on appeal after the anti-SLAPP ruling comes down in December. Let's see. There's the 2 federal cases. I'm sure I'm forgetting somebody, right? Let's see. Off the top of my head. Bianco. Smith line case may be dismissed if she doesn't do anything in the next month and a
Made
half or how
reference
much ever
to-
time she has left.
This vehicle.
So I don't think there'll be a
driving
trial to be
into
televised
the
anytime
state you
soon,
were
I guess
not
is what I'm
injured.
trying
Did
to
you
say.
file a claim in this matter?
But a state case could be.
No, I did not.
Do you consider yourself an injured party in this matter?
No, I do not.
Do you yourself
Jane
know
Doe.
if anyone filed a claim in this matter?
Point.
Can you be more specific?
Thank
Do
you.
you yourself know if anyone filed a claim in this matter?
I kind of figured he would have
Just
asked
in
these questions
general?
the first time this guy was on the stand, so I'm surprised this is happening
Whatever
now.
your
I thought they'd
interpretation
skip
of
this
that would be.
nonsense.
I would say yes.
And do you know what that claim was?
I would imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. I imagine that they would file a claim with their insurance company to have those bills paid.
So you had knowledge of what was filed to their particular insurance companies?
I have no knowledge, but my assumption is that they would have filed those bills.
So it'd be fair to say you don't know for sure.
That was my testimony.
Is that the answer?
Yes.
Yeah, I definitely think the guy is an injured party. There are lots of injured parties, but he's not putting himself in that role as the investigator.
As lead investigator for this matter, where are you, to your knowledge, aware of any GoFundMe type of things? in
Objection
relation to-
relevant? I'm sorry.
Do you mean as it relates to?
As it relates to the incident.
Overruled, the witness may answer.
Gosh, come on.
I have no direct knowledge, but I assume that there are some GoFundMe pages out there. It's typical in something like this.
And what do you mean by typical? You've seen this before? Is that what you mean by
Nothing
typical?
as terrible as you
We have a
do.
very loving and caring community where a lot of times when bad things happen to people, people pull together.
I'm gonna pull this
and
comment off 'cause I know
offer
you're talking about
financial
Manson. I'll get it in
assistance
the
to
lull
help
here.
people.
You don't want people
Is
to
it
think you're
fair to
talking about
say
this
that
idiot.
there's a lot of communities like that across Wisconsin?
Yes, I think there are.
Sure, there are a lot of decent people. A lot of them coming to testify in this trial, and there are a bunch sitting in the jury box. While his brain is smoking, back in the 90s as well, he ended up at a house of one of my
And it
friends,
would be fair to say that you've worked
and nothing weird happened, and he left. After a while, and that was
Extremely
it.
close.
So.
with the district attorney's
That's
office
all I know
during
about
the
him from
entirety
a
of this
kind
matter.
of
Would that
personal
be fair to
basis.
say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
Yeah.
I would like you to define it extremely.
Then just say, no,
I'll answer yes if that helps.
thank you. He's in boss mode now.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes, it's very typical. That happens in most larger cases, especially a case of this magnitude. There would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in it?
Used to volunteer to help the DA's
investigation
office
that-
on child molesting cases, and we would be careful
has
not
that
to
honor?
come sit all right behind the DA. We'd spread ourselves out to the
Objection,
courtroom,
Bay.
people who were
Grounds.
helping to
Sustained as
not make it
follow-up
look like the
question.
state had
Are
even
you
more
the only-
resources than it did.
Detective directly involved in an investigation that sits with the prosecution.
Where do you want him to
Talking about
sit?
this case or any case?
This particular
or-
case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in
Yeah.
reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
This is dumb.
So would you explain who the other officer is in the blue suit over there?
Objection to the relevance, Your Honor.
Grounds.
Sustained.
He also said
I just wanna know
detective, so,
who-
and
Sustained.
investigator, so maybe that guy's not.
Reason for the
Please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. How is it not relevant?
Because it wasn't relevant in the first place, and you shouldn't have been allowed to ask it in the first
Nobody
place.
knows who he is.
Well, you don't need to know who he is.
Nobody said
It's
that.
not
I'd like to-
relevant to
I
the
don't even
issues
have a
that the
back
jury needs to determine. Next question, sir.
Is it Asking or telling?
Oh, not this again. Because she can tell him. This isn't a volunteer court.
I'm assuming that's asking.
Do what you want.
You know what the other one would entail.
Yeah, it would entail you revealing even more clearly
Do you have
that
a
you're somebody who
question, sir?
wants to beat
Yeah, I
women.
do. I would like to get to it. Thank you.
We'll get to it.
Please do so. Thank you.
I will.
So his ego clearly isn't going to help him with his jury either. But again, he's not going to let a woman tell him what to do. You can ask,
So
but you
seeing
can't
as how
tell.
you
This is what he
settled
blew
the
up about
prosecution for the
yesterday.
entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Oh, not this garbage.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection,
Grounds.
legal conclusion.
Grounds.
Sustained.
This opening statement is going to go
You
crazy.
are aware that only a living, breathing human being can actually file a claim.
That is
An
stupid.
entity cannot
That is
walk
stupid.
into anywhere and file a claim.
if you
if
just
it's not even a
Murdered
real
someone who had
person.
no family or friends, there could be
Objection,
no
you are aware
claim
of that,
against
right?
you because only a
Go ahead,
living, breathing
Julia.
person can file a claim.
Move to strike the statements by Mr. Brooks.
Yeah, I
Also
absolutely agree with
object to
this.
the question that was asked at the end is irrelevant, argumentative, and calling for a legal conclusion.
Yeah, he likes to play lots of
The-
legal
roles.
conclusion in any
The
way.
court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the
His
statement.
argument to the judge
Also
that, are
says
you
the
asking me or are
statement
you
below.
telling me?
No, I
Judges
definitely
tell people
object
what
to
to
that,
do.
Your Honor.
Your objection is noted. I'm
I'll
going to
take
have
it.
the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I'll take exception to that ruling. And would like a legal finding of fact.
Your objection is noted. It's overruled.
And that's a judicial determination.
So the opening statements usually come at the beginning.
Thank you. Be seated.
He deferred his until the state rests its case. He could still
Go ahead, Mr.
not do
Brooks.
one,
Continue
but
with your
I do
question.
not think he's going to skip the opportunity this time to talk directly to the jury. But he deferred it. He still doesn't have to do it.
Have you ever had any interactions with this entity, state of Wisconsin?
Boy, is this
Mr.
true.
Brooks, under 90611, I'm not going to allow the witness to answer. It's vague.
There
Please.
was no objection.
Under 90611,
90611.
I shall
You should read it
exercise
sometime.
reasonable control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this
They're
witness.
gonna keep
Yeah,
coming
it's
up.
atypical,
And
but
I
so
determined
is
at
this.
that time that they weren't relevant. So next topic,
They're gonna
please.
keep coming up.
Under 90611, sir, please move on to a new topic.
They're gonna keep coming in.
For the cross-examination, I will
Close it.
end.
Do you see the state of Wisconsin present in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next
Final
topic
warning.
or the cross-examination, I will
You
bring
don't,
it
you
to
don't
an
gotta
end.
you don't gotta keep doing that, Your Honor. You don't gotta keep doing that.
It's my responsibility, sir, over this trial.
I'm informed. And
Thank you.
And I
Next
respect
topic.
that. But it's relevant for the jury to know the
He's
truth.
trying to assert control
deserve
over the
to know
judge.
the
He
truth.
cannot
To
stand.
strike, Your Honor.
Granted,
cannot
the jury
stand
will
that woman
disregard
Right.
those last
talking
statements.
to
They're
him
not
like that.
relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. It's
Noted.
untruthful.
It's not
All right,
lawful
under
law.
90611, I am now
Common law.
stopping the cross-examination.
Researcher
Any redirect by
and
the
scholar
state.
Darrell Brooks now informing the
Objection to
judge that that is not
And
lawful.
all
Noted.
legal finding of fact.
Attorney Opera, any redirect?
Yes, just very briefly, Your Honor, I would like to
Cross-examine
display for
closed.
the witness only exhibit
This may explode before we even get to the opening
178.
statement, but it's,
Objection.
I put the
I haven't
odds
seen
of
the
this going to
exhibit yet,
bananas
so
level
Take it under
craziness with
advisement.
the opening statement at
Objection still because
98.7%.
You may show it to the witness.
There needs to be an answer to why the jury's not being told information that they deserve.
She's going to have to shut this down.
Go ahead, Attorney Opera.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems, objection, because this seems like a whole new exhibit. This was never mentioned before. It was never,
I haven't seen it. I can't rule on it, sir, so let
I
me
mean,
see it, and I'll
when
take
did
your
it become an
objection under,
exhibit?
I'll
It
take the
was never an
objection under
exhibit before.
advisement. Go ahead.
I haven't seen this in any of the exhibits that I have, so how could it just be created now and be made an exhibit?
Depends on what it is.
Go ahead,
I
Attorney
have all the
Opera.
exhibits.
Go ahead,
It
Attorney
depends
Opera.
on
I
what
haven't
it
seen
is.
it yet. There's nothing on my screen that I can see. I see it's now playing.
So now we just creating exhibits now. I have all the exhibits, and this was never
Evidence
in-
Professor Darrell Brooks is now concerned that the judge is not controlling the exhibits in an appropriate manner. You got to respect the guy who takes time out from beating women and murdering innocent
Sir,
people
do
to
you
learn the law in such
Recognize what's
detail
contained
prior
in
to being
State's
held to
Exhibit
account in court.
178.
Objection,
Overruled.
relevancy,
Overruled.
leading.
Go ahead and answer.
Yes, I do.
What is it?
Objection, leading.
Overruled. The witness may answer.
I'm still gonna object. How is it?
Mr. Brooks, I ask that you honor
I have all
the ruling that
I
I've
have
been
all the
made.
exhibits though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me, and this was never in the exhibit. So how could it just be made in the
To me,
I'll
he
take
hasn't
this up
clearly
outside the
done,
presence of the jury, but I'm going to allow
anything
it.
yet that I
be
can
stated
actually
for the
tell what
record?
he's
Can
gonna
that be
do.
explained?
No.
In theory,
the
this
jury
would be
will
in his,
disregard the statements
opening
made
statement.
by Mr. Brooks. They're not evidence, and the statement
So this
continue.
exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted, it's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks
This is
standing in front of the Ford Escape. This is the video in which that still photo was taken from.
Yeah, he asked about it.
Objection, how does he know that?
Overruled. The witness may answer. I'll give you the opportunity to question him about it when the
For the
state's
state
done
side,
asking the
laudable.
questions.
This
Go
has been a
ahead.
pretty quick trial so far for a case of this magnitude. When you
this
think about
video
some
from,
cases,
sir?
it's drag on for
Objection,
months and
leading.
months and months.
Overrule the
They
witness
have
may
been
answer.
efficient.
From Mr. Brooks' social media account.
Okay. Your Honor, move to admit 178 and permission to publish.
Oh, they're going to show the whole video of them
Objection.
swinging the guns around and gang
For
signs and stuff.
relevancy.
I'll find that
Still
it's
don't know how
relevant.
it's
I'll
obtained.
receive Exhibit
Well,
168.
you said you
Permission to
can't-
publish
you can't tell who it is.
Granted.
You asked.
For the record.
It's 178, Your Honor.
No, could you please tell me the length of the video?
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
Yeah, because that would be more
All right, thank you.
incriminating.
And
I object to that, and I would like to make an offer of proof of my appeal.
We'll do that outside the
Stupid.
presence of the jury, but I will allow the state to play it in its entirety without
Your Honor,
audio.
I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to
But
address.
how can you play something that's not, that I didn't even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling. Brooks has never
Actually,
been
Your Honor,
involved in
I
a trial of
changed
this
my mind. I
magnitude
would
where a
like to
judge has
play
made
the
so many
audio.
reversible errors,
This
in his
is
opinion.
mind-boggling.
It's just mind-boggling.
I want to have it played first without, and then I'll make
I
a
will
ruling and I'll
say,
take that
it
up.
could be true that it's not that hard to boggle his mind.
I
So
understand.
that may be reasonable, what he's saying there.
So we will play the
Imagine
entire
his state is,
video. Your
his
Honor,
mind
2
is in
minutes,
a
33
constant
seconds.
state of being
My
boggled.
objection to that, why does the whole video need
Oh,
to be
here we
played?
go.
Is this setting the foundation?
It's relevant.
Setting the
You question
foundation
the
for you
officer
being a
about it.
murdering idiot.
You
I
question this
question him
detective
about,
about
I
his
question him
knowledge.
about the still frame from the video.
There he is. Yeah.
The
And you
video
said, how
wasn't
can you know?
even in-
He said, I saw the
in
whole
the
video.
exhibits that I
Now you get to
received.
see it.
It actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
Got a little Mac 10 type thing back there. I don't think that was even the same gun I saw in the other picture, but we'll see. One of the least accurate things you can shoot, but if your goal is just to spray bullets, that's what it's for. It's too bad they don't have the volume, because I'm sure he's giving life-affirming advice to youth, how to grow up and be responsible.
Play the sound. I want to hear it now.
Yeah, exactly.
I'll address that later.
We address why it is.
So this was a mistake on his part to ask questions about the cross-exam, act like the guy couldn't know it was him when the guy said, I watched the whole video and it was you, and he pushed that, and now the door is opened, as he said earlier, and they get to see a little bit more of who this idiot is. Yeah, remember, he tried to claim you can't know that's me out of that video. That was his idea there. Oh, yeah, maybe it was a Mac 10. He doesn't. He doesn't. I mean, any animal that you spend any time around has a better sense of shame and regret if they do something they shouldn't do than this guy can exhibit. He's completely, it's a Mac 10. He's completely self-absorbed. This could happen if he blows up. He's, I guess, shut up for a minute here.
Go ahead, attorney, after the video is finished playing.
Thank you. Sir, did you see during the playing of that video the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled, foundational, the witness may answer.
Yes, I
A lot of.
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Hopper.
Overruled, the
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court, as states exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled, the witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video. And
Kaboom.
later standing next to the Ford Escape.
I wish I had an explosion
And do you have
graphic I
any
could
other
put over
questions,
this.
Your Honor?
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of
Well,
Detective
she has
Casey.
it.
Objection. I don't consent to being called that name.
Okay.
Noted.
Well, who
Do you
cares?
have any questions for the witness?
This when did this video? When was this made a exhibit? Because I don't have it.
Objection, that's not a question for the witness, Your Honor.
That
Sustained.
was a question. A question. When was
Sustained,
this
as to the
video
form
made
of
an
the
exhibit?
question,
When was this video made an exhibit? That is a question.
Yeah. Hard to believe this guy would get
Object to
violent with
question
women, isn't it?
Directed at the
Yeah,
witness,
or
Your
kill
Honor, it's
people.
beyond the scope of his knowledge.
Seems
Well,
like
he
such a
said he
good
saw
guy.
it.
but that's not the question asked. So you can rephrase your
But yeah, he
question.
had the
if you
SUV.
wanna-
When did you
And
see
him
this
in it.
exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
Because you're an
It would
idiot.
be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please,
and
and
faces.
admonish them?
Yes,
Because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir, I'm good. Can
Who
I
cares?
do my job?
Who cares?
State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody never see
However,
nothing.
Is she supposed to watch all the cameras?
I'm advising both parties to show
Come on, man,
decorum.
this is not fair.
And
Surveillance video
restraint.
specialist Darrell Brooks declares that the judge should be able to monitor all cameras
Time
simultaneously.
and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
I saw the video.
Look at the expression on this
within a
guy's
few
face.
days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection,
I
argumentative.
didn't necessarily need to do it.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Yeah, it
Sustained
was brought
as
up.
to
It was
the
not
form
brought
of
It just
the
wasn't
question.
shown.
It's facts, not in
But it was
evidence.
brought up though.
If you had seen it numerous times before today, why did you need to see it again to make sure if any questions were asked or
He didn't
however
say
you
that.
refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
Just to
I'll
remind
see.
myself how dumb you are.
Objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
Boom.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts, not in evidence.
Sustained as to the form of the question.
This is mind-boggling. This is mind-boggling.
His mind is boggled again. Just drop
Can you
it.
clarify again why you viewed the video this morning?
Objection, asked and answered.
Sustained.
Ooh.
So you're gonna sustain everything?
You're going to
It was
sustain
already
everything?
answered, sir. Next question, please.
And I'm asking for clarification.
You don't get it.
Next question, please.
I don't got no more questions, man.
All right, thank you.
This is mind-boggling.
Detective, you may step
mind-boggling.
down. I'll excuse the jury.
What you people is trying to do is not fair. Hide things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence
There
of
is
the
no
jury.
chance
I'd
this
ask that you
opening
honor
statement
my
is going to be
decision do
rational
that and you show courtesy
according to
and
any
decorum.
rules.
Because you asked.
Mr. Brooks, please.
Because you asked.
He's still trying to push the judge into the corner.
That's the
You
only
can't tell me what to
reason
do.
you asked.
I'm will only obey you if you ask me.
I see what you people are trying to do. It's not right. It's not fair and it's not
You
right.
people.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence.
Yeah, he knows how to use
All right.
words. He doesn't
First of
apply
all,
anything to himself other
Attorney
than what
Hopper, if
he
you can
wants
make
at any
a
given
record
moment.
as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained, that video was not part of it, do you think I would sit here and be this irritated
Mr.
by
Brooks, I need
something
to
that
make
I've
a
saw?
record, so
Yeah.
just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
So his theory, the
Based
judge
upon the
can't
offer
tell him
proof
what to do?
provided by the state, and it was
Is a bad
provided
theory.
to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated I
That's
would-
inaccurate, Your Honor. Can we have the prior counsel testify to that then?
Oh, yeah,
Not at
I
this
have him
time, sir.
I have
testify.
not obtained that. Right now, that was my first time seeing that as an exhibit. That's
Mr.
why I
Brooks, I
raised the issue.
presume, and you can correct me if I'm wrong, but you're familiar with that video?
Yeah.
Yes or no?
What does that have to do with what we're talking
Because
about?
I'm gonna make a finding based upon what I viewed in that video, that there's absolutely no surprise to you.
Yeah.
It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video
Yeah.
is relevant for
May
a
not even
number
be
of
over yet.
different
He may
reasons.
get
The first
nastier.
of which,
It's hard to
it goes
see.
to
Before
identification
it's
of
finally
you,
closes off,
identification of the
he's very
vehicle. You
agitated right
opened
now.
up the door
He could blow up
through
more.
your cross-exam of Detective Casey
He's not gonna
about
go into the
his
opening statement
ability to identify
in a,
you
calm
in
frame of
that
mind, so this could
video.
Bad.
And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that. And what relevance, if any, that evidence have, but you opened up the door for the state to show that video because you directly
He is.
attacked the
And
credibility
he did.
of Detective Casey.
He did open the door.
Through his knowledge of it and the identification by him of you in it, because the still image was of your back.
Okay.
So
and-
that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists,
Or that it's you.
and that is my finding as it
What do
relates
you
to
mean by
that.
it's no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can
didn't
make an
have
offer of
anything to
proof
do
on
with.
that, because obviously
Yeah,
they
it's-
marked it as an exhibit.
But
They
with
can
all
also
respect,
go
see
ahead,
if they
Attorney
manage to get to an
characterizing
opening statement
what I-
before
what
that
I
or not.
said, and the record needs to be clear. The issue that I raised was how did this, at the last minute, out of the blue, become an exhibit? That was
Attorney,
the
go ahead
issue.
and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection.
aware.
He said social
There's
media. He
nothing
didn't say what it
Hold on,
was.
sir, stop interrupting. We have to make a record of it. You've
Then make the record
interrupted multiple times. I've been abundantly patient
record clear.
with you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me to be
me.
quiet?
Stop rolling your eyes at
Are
me.
you?
Stop
I'm
mumbling.
looking right at you. I'm
There
not
goes
rolling
the-
my
are
eyes.
you
No, you
asking
have
me?
throughout. I've seen it
She's
and
gonna
I
have
made
to
note
deal
of
with
Looking
that.
at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Eventually,
Go ahead, Attorney
she's going to have to
Hopper.
crank
Thank you,
down
Your
if he
Honor.
keeps pushing
And
that.
just to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in
Everybody
the
in that
still
courtroom was
shot
talking louder.
of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial.
Absolutely.
Originally, I wasn't going to ask for volume. Then I did because he pushed it again, and his voice and his mannerism of speech, I thought would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant who continues to suggest and impugn the integrity of this court and this prosecution
Preach
without
it.
basis.
She
He
is
doesn't
preaching.
like it because the evidence is stacking up and stacking up. And whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no
Epic
law,
dunk.
he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks because, again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a
She was
fair
on her last
trial,
nerve
and of
when she
our
came in this
efforts
morning,
to
and
run a fair trial.
everything
We
she
have
is saying
ethical
completely
obligations as
warranted.
well to be
Absolutely.
fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion.
And there should be.
So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
Are you
I
asking me or
object to that.
telling me that?
My previous ruling doesn't change in any way that the
That was his
exhibit
newest
is
attempt to try and,
relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court
he's
that
continually
it would be
escalated
prejudicial based upon the lyrics that are
his
in
behavior
that video
and his
my decision
cutting
to
remarks
admit
to the
video
judge to try and
without
see where the
audio
limits are.
stands. I do want to
And to
take
put
up
her in her
two
place.
other issues.
The are you
There was an
asking me or telling me
objection,
thing being the
to
most
questions
ludicrous because
regarding,
she is under no
cross-examination,
obligation
so
to
the
ask
objection
him
provided
things.
the
She
state.
can tell him
One had
things.
to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So, Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction? I believe it was with your mom and possible testimony of your niece and nephew.
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would
No,
recall him. I wanted to take it up outside the presence of the jury.
No, he wants to go back to-
know.
So
Yeah.
are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think
No.
I deserve that much if it's a fair trial.
No, you're
What
not going to get what you
information
deserve,
do you want to
unfortunately.
provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight.
But it was all true.
Now don't nobody know what I'm talking about.
No, they don't.
I don't
There
know
was a reference made
specifically
to
what you're talking
there's a
about,
reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still gonna present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling
She,
on an
she's been
exhibit.
laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
He's just a minor.
I
her to sit
haven't, I
there-
haven't made any of those observations,
I didn't
sir.
say
What
you.
I've observed.
I didn't say you, Your Honor.
No,
But
what I've observed is
listen, please.
Go
Listen.
ahead.
For her
He
to
gets to
sit
shut the
there
judge down, he thinks.
and try to play it off as if she's not referencing to me, she must think I'm an idiot.
Well, I do.
Nobody
That
has
is very
stipulate to that.
disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
But to be
What are
fair,
you
a
talking
murdering
about? I
idiot.
don't know
Her
what you're
laughing
saying.
under her breath. Her trying to cover up the microphone so they can laugh and he and key. That they've been
He
doing that the
hates
whole
women.
time.
He really hates women.
I didn't
Any
say
specific
anything. I didn't say
instances, sir,
anything
because
about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I
involved
haven't
with
noticed that other than the one thing you pointed out
Well,
today.
we have
that-
cameras. That's what the
Mr.
cameras are
Brooks,
for.
let's refocus our attention on what we're here for, and that's
Okay,
this
then
trial.
I take that
And do
as-
you have
I
anything you
take
want to
that
put on
as-
the record?
I'm putting it on the record
As
if I
it
get a
re-
chance.
No, you need to let me finish. As it relates to the video and my decision to admit
She
it.
just admitted that she just
sure how
now
old he is,
came with the exhibit.
actually.
It was
He
not,
has
she just
kids that
said, she just made it an exhibit.
old,
It
huh?
was
That
not
doesn't mean
an
it wasn't
exhibit
turned
before she
over
made
to
it
you. So
one.
do you have some legal basis, sir, for your position?
He has nothing.
Because I'm not
What do
aware
I
of
need
any.
legal basis for when she just admitted?
It's a good point. What do you
on
need
the
a legal
record
basis
that she
for when you're
just
making a legal
made
argument?
this exhibit
That is a
up?
good point.
No,
right
she
now.
didn't. That is a complete mischaracterization, sir. She did not.
That's what, so she wasn't
Create
implying
the
that by saying that
exhibit.
she can
She did
pull
not make
anything
it up.
out of her suitcase.
And she's telling the truth. They didn't
So
give me an
that's a
exhibit.
figure of
During-
speech.
Okay, so what is it
Alright.
implying to? What would that be implying to?
As
He's
How
not
would
arguing.
anyone-
All
with
right,
how would
you.
I'm
anyone in
moving
my
on
position-
because you're not providing
How
me
would-
with any
how would
legal
any-
basis
I didn't even
for
finish.
me
You
to.
told me that I can make the record. I'm attempting to make the
well,
record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said
anything?
that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me.
But
You're
how
on
do
a
you-
rant,
how do you know I
you're
wouldn't get to
providing
that if I
commentary,
didn't finish?
You're not providing me with anything from a legal basis for which I would consider
And
changing
he just
my
said I
mind.
don't have to have a
So
legal
the state's
basis.
withdrawn their request to play the audio.
Then why play the video at all then?
I've
Because it
already made a
shows you're an
ruling on
idiot.
that. You're questioning the ruling. You're not asking me to reconsider it based on any legal
There
basis.
should be a legal reconsideration of it.
What's the
Then you need
basis?
to provide me with the legal
has
basis
nothing.
for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yeah,
Yes.
that's what your lawyers would do. Remember
That's
you wanted to be your
ridiculous.
own lawyer?
You're
Remember
representing
that?
yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly.
All
at
it
the-
did
at the
was
drop
show
of a
you
hat.
that
Let
you were
me
in
try
it
to
in
find
the
some
video you
legal
knew you
thing
made.
to combat-
When
How
you
am I
tried to
supposed
act
do
like
it?
you weren't in the
The
video.
bottom line is you opened the door to
It
the
doesn't.
playing
It
of that
doesn't.
video.
We're not talking about
And the
opening
video
no
was
doors.
previously provided to you during
We're
discovery.
not talking
There's
about opening no doors. We're
absolutely
talking about
no-
being fair.
There's
Because
absolutely
if I
no
would have did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise.
with
by
all
the
due respect,
exhibit.
if I had
Right.
done that,
I am going to move on.
if
from
I
this
had done
topic.
that, it would have
Mr.
been a
Brooks,
big
I'm
thing.
advising you.
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down
I
and
don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me in
trial.
contempt
Mr.
for the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please.
you mean? I'm asking. What do you
Mr.
mean?
Brooks, you continue to
That is
come at
not.
me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not
Remember,
fighting with
before
you.
he was caught
not.
murdering these
I'm
people,
going to give you
You
he
said
one
I'm
filed
last
an
not
application
opportunity
for
to
beating
sit down
women.
and be quiet so I can make
Committing
a
other
finding
crimes
as
of
it
the
relates
felony.
to
Need to
other
do
things.
that. Are you asking?
I
me
don't need
do
to
that?
ask, I'm telling you.
Yeah, exactly. Finally, she said that because she's the judge.
Thank you.
You have to assert the
There
authority.
were two other issues that came up that I advised
Are
the
you
parties
asking me
I
or are
would
you
take
telling
up
me?
outside the presence
Stupid.
of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey.
Cannot do
There
this.
was questioning
Please, Judge.
by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics, is my first question.
Okay, why was it an issue with me bringing this?
Mr. Brooks, I'm only going to ask you one more time.
Yeah, I mean,
and
don't let me-
If I don't understand what
You
was
do
the problem
understand.
in the get-go with the question, how am I supposed to answer it now?
Mr.
Well,
Brooks,
when you fire your
listen to
lawyer,
me, please.
it's on you.
I'm going to ask this question
One
one more
more
time.
time.
It calls for
I
a
don't like
yes or
I don't
no.
like your tone and the way you're talking to me. I don't.
Mr.
I don't
Brooks?
appreciate it.
Sit down. I don't care if you don't like my
I'm not
tone.
gonna-
You've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout
Exactly.
this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too.
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's
Stop
not accurate.
talking.
What you mean stop talking?
I need to make a ruling. Okay,
Well,
I'm purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's
right
talk to
now.
each other like adults then.
God.
Mr.
Because
Brooks,
I've never told you to stop talking.
No, I just
I'm
talked
going to
over
ask
you.
this question one more time.
And
If
you are
he
not
doesn't
the
answer it,
judge.
I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell?
I don't know
Yes
how
or
she
no?
even keeps this stuff straight.
What was the problem with me asking the
All
question
right,
about
he's
Then
not
no.
answered my question. We'll move on.
I'm
not
trying
giving
to
that
understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're in
I know?
recess, 15 minutes
How do
from
I
now.
know
Take
what
care,
I'm supposed to answer if I don't understand? And I don't agree to a stop.
That's outrageous. Just outrageous. Well, 15-minute break, and they'll come back and I'm sure argue some more, and then the state's going to rest, and probably more argument. I will be amazed if they can successfully kick off this opening statement to even get it started and how wild it would be. But we're at 12:30 time here, so I'm going to have to take off. And I appreciate everybody who came into the stream and chatted about this some, because it's pretty remarkable. There are probably some things to learn about legal procedure in it and just how a trial works. But it's fascinating too, just to see the judge have to deal with a guy like this, and the kind of character that would kill people. It's on display for everybody. But thanks for coming in, and I'll talk to you guys later.